judiciary bail and bond policy guidelines, together with several decisions of superior courts in the land, that is the Court of Appeal and the High Court. And Your Honor, that the list provided in the judiciary bail and bond policy guidelines is not exhaustive. But without going to the particular facts which my learned senior Mr. Kula is following me to talk about, that list includes as compelling reasons the likelihood of interference with witnesses, the likelihood to interfere with ongoing investigations, and the likelihood to interfere with exhibits. In concluding on the legal issues, the primary purpose of bond is to ensure that an integrity of the trial before you. Protection of the integrity of the trial before you. So that, Your Honor, even where it is shown that an accused person shall turn up for trial, if released on bail, where releasing an accused person on bail will prejudice the integrity of the trial. Where releasing an accused person on bail, even where it is shown that they will attend trial, where releasing them on bail will prejudice the trial and therefore the integrity of the trial. This court has a reason, a compelling reason to deny them bail. And Your Honor, a likelihood to interfere with witnesses, exhibits, or ongoing investigations is a high likelihood of interference with the integrity of a trial. That is our submission. Allow me to say the last thing on Section 8, subsection 2 of the Magistrates Court Act. Section 8, subsection 2 of the Magistrates Court Act deals with the court's jurisdiction, I mean subordinate court's jurisdiction, to enforce Bill of Rights or questions of interpretation relating to Bill of Rights. That jurisdiction is limited to Article 25A and B of the Constitution. The rights under Article 25A and B of the Constitution it is a clear statutory statement that this court's power to enforce Bill of Rights is limited to the rights under Article 25A and B and nothing more. So that, Your Honor, reference to constitutional provisions as regards Article 49 on bail can only be made in respect of 25A and B. Anything outside of that is outside your jurisdiction, and where you have no jurisdiction, you pen down on those questions of constitutional interpretation if raised. I am honored to appear before you. I thank you and invite my learned senior, Mr. Akula.
And on your file an affidavit sworn on 19th May 2025 by Mr. Robert Brown. 19th of May 2025, this morning. Yesterday, Your Honor.
That is very good.
Thanks for your
19.
You filed this morning.
5.
Yes, Your Honor. Your Honor, it is sworn by Robert Brown.
Sworn by
Robert Brown, an ESCC forensic examiner. There are the factual reasons or grounds to reject bail are deponed from paragraph 1 to paragraph 12. However, I will cluster them into three, 1 to paragraph 12. And however, I will cluster them into 3 compelling reasons. The first one, interference with witnesses. The second one, public safety. And lastly, the severity of the offense. For the first compelling reason, my Lord, Your Honor, we submit that subject to this case, there are other ongoing investigations. Which at paragraph 3 and 4 found that paragraph 3 and paragraph 4 of the affidavit confirm that the accused person, through his agents, the accused person, through his agents, attacked ESCC and LPS officers in lawful exercise of their duties. This has been reported and is captured under annexure number R38. Italy Police Station. R38, PR38, and extra PR38. Your Honor, we have annexed 4 photographs of security vehicles.
With your kind permission, I wish to raise an objection. An objection, Your Honor, is founded on Section 106B of the Evidence Act.
That is your name.
Willis Otieno, counsel for the first accused. Section 106.
Yes,
Section 106B
on electronic evidence.
on electronic evidence.
You get your time.
No, I wanted to raise an objection because it's time to refer to it.
You get your time, let him continue.
Also, we have a next
I want to conclude the direction first. You can continue.
Yes, Your Honor. We have next a series of photographs marked as RR1 to RR37.
One, two, RR
37.
37.
Your Honor, those photographs depict vehicles belonging to ACC, National Police Service, that were vandalized at the residence of the accused person. Yesterday, when the officers were executing the lawful mandate.
Executing?
The lawful mandate. That is, doing a search pursuant to miscellaneous application E716 of 2025.
Come again. Miscellaneous application number
E716
E716
of 2025. That is detailed in paragraph number 4. Do not photographs RR3 to RR10. RR3 to RR10. They depict motor vehicle KCH 046T.
come again.
046T. After it had been vandalized. When our photographs R11 and 12 depict KCD 628X. Photograph R11 KBU 734Y. And photographs 541U, ACF 541U. At paragraph 7 and paragraph 8, the officer depons.
Sorry?
At paragraph 7 and paragraph 8, Mr. Rono depons in these vehicles. Important documents were taken. Now we take judicial notice of the position of the first accused. The witnesses in this case, Your Honor, upon disclosure, are his subordinates. People employed under his government. What is the test of interfering with witnesses? It is not beyond reasonable doubt. The test is just a reasonable prospect that the accused may tamper with the witnesses.
The test is?
A reasonable prospect that the accused person will tamper with the witnesses or the evidence.
Perhaps, and I'm aware of the directions you've given for the diaspora. Perhaps we need your guidance whether counsel can go outside the content of his affidavits and claim to bring averments that are not contained in the affidavits, because that will prejudice us in terms of our response. Because there is no averment in the affidavit to that effect that the proposed witnesses are the subordinates of the government.
I'll give a guidance again. Wherever you pick along the way from both submissions, kindly bundle them together. Once you rise, I expect that you address all the issues in one sweep.
I'm wondering.
But let me record you first. Factual witness this record is objection. Everyone,
I will repeat your honor.
How long more? I thought we were going to take 3 minutes. Now we are going to we sit here the whole day. Just off the cuff. How long more?
Around 10 minutes. 10 minutes. Just summarize this.
10 minutes. Continue, Mr.
Yes, sir. I will repeat
You
that.
have 10 minutes.
We are submitting that once disclosure is done, the witnesses will be calling our officers from the first accused government. Those are the subordinates. I'll go to the second link. severity of the offense.
Three.
I'll go to the second compelling reason. When approval of the judgment, the amounts will appear casual.
The amounts will appear
Minimum 1 million. But we believe Your Honor will win this case. And we draw your attention to section 62(1) for a second. 62(1) for a second. In the event you succeed, that provision is very punitive.
in the event.
We succeed.
We is the
DPP
DPP.
prosecutes this case. We get a conviction.
If is successful.
Yes. We will be moving to section 62, subsection 1. And you know that the severity of corruption cases for someone to interfere is subject to the positive. Lastly, I've alluded, Your Honor, to what transpired yesterday. And I've said that investigations with regard to other cases are ongoing. Our submissions is that if we release the accused person today, what transpired yesterday, Your Honor, will occur. And we are apprehensive that in the interest of in order to protect the integrity of the criminal justice processes, a plea report before this court and decide on this matter. That will be a minute.
Sorry, Your Honor. Just to underline that our prayer is that the first accused be denied bail. That probably is the last sentence you have done. Thank you.
How many of you
Please, I'll take the first one.
Because I listed how many? Listed 11.
Yes,
And one.
not all of us, certainly.
So how many? Just to manage our expectations.
About 5. About 5 or 53. We do not want to we don't want drama, we just want to go for you know, because the issues are straightforward, Your Honor. But let me start by introducing Senior Counsel John Kaminwa. He's our guide.
I'm here, Your Honor.
Hello, Dr.
May I say good morning?
Good morning. How are you?
So we have an 57, then Aaron Dubi is also here.
So that is
Aaron Dubi. Your Honor, let me be the first one to just give some.
So, let me at the outset state that the prosecution is causing unnecessary drama in an otherwise straightforward matter. And our focus at this point should be the rights of the accused person, who remains innocent unless and until he is proven guilty. So no amount of reasoning.
You will be slow on you.
Yes.
Yes.
So no possible grounds can be advanced that can be directed at taking away the accused person's rights. That should be the starting point. And sometimes, Your Honor, as a counsel, it is factual. It is factual.
The right note.
Yeah. When we propose,
but I'm sure Dr. Hamino is smiling at you.
when we propose,
I'm sure Dr. Hamino is smiling at you.
in fact, I'm one of the few who have the advantage of having interacted with you in the previous position in JSC. I know you have a very sharp mind. We don't want to come here and start. Previous position in JSC. I know you have a very sharp mind. We don't need to come here and start. Previous position in JSC. I know you have a very sharp mind. We don't need to come here and start citing to you positions of law and affidavits. So I cannot, but in this stretch of imagination, expect that a court.
I'm making a backup for the.
Yes.
We don't trust technology.
The technology.
I'm making a complete backup.
Yeah.
You can continue.
So I dare say, Your Honor, that even the prosecution, because they're also lawyers, we all pass lawyers before we
Sorry, Your Honor. I know the court warned us of decorum, but we plead. I am just 12 years in practice. We plead that senior Macha area doesn't get personal.
There is a special reason, Mr. Njeru. I did what I did to your side. So that we remain focused.
Yes. With tremendous respect. What we have here is lawfare. Which I urge you, Your Honor, to take judicial notice of, because we live in this country. We are interacting with social media. We know what is happening in our country today. And none of us can purport independent agencies are being captured and being used to weaponize matters of justice. That's what law is all about. Where you use legal processes to attain an ulterior objective. Your Honor, I make a confession to you. I was, and you shouldn't allow it. Your Honor,
Jero.
I'll give you a context. I'll give you a context. I'll give you the context.
The focus.
Yes, I'll give you the context.
Focus here, Mr. Jero.
The context. I'm not here to talk about where I was and
Sorry,
it's just to indicate.
No, sorry, Your Honor, we are forced to object once more on the question. The factual matter is that with respect, he cannot tell us from the past. We would believe him, and I know he's a very truthful man, but for us to believe what he's telling you to believe, let him give us an affidavit of those facts so that we're able to respond to those facts. Without that, we humbly plead again. We humbly plead that he gets back to the case and not tell us the other things that are factual and there's no affidavit. We plead with him. We understand that is previously the commissioner, we understand. But let him get back to our case. Thank you.
Look at the affidavit.
A minute, Mr. Jero. I complete reporting.
Your Honor.
Mr. Jero, your brief response, you're responding?
They've made general averments to start with. Problem about it. They serve us in an affidavit this morning. We expect us to make an application for adjournment so that you can file an affidavit. And in the meantime, the accused then the affidavit itself is marked with general averments. Responding.
You responding to the objection or you continue with your submission?
I'm responding to that. Yet in his own affidavit, he has made very general averments that are in support of denial of bail. Then he respond to that, at least from the back, at the very least. That should be expected. He can't have a steak and eat it. The subject of these proceedings is the accused person. The rest of us are speaking here, and then we'll walk away. But this is the subject. That's the person you should focus on.
On the law governing Mutembei, that is the issue of the
No.
is sworn by Robert Bono.
Sworn by
Robert Bono. And EACC forensic examiner. There are the factual reasons interference with witnesses, the second one, public safety, and lastly, the severity of the offense. For the first compelling reason, my Lord, Your Honor, which at paragraph 3 and 4 confirm that paragraph 3 and paragraph 4 of the affidavit confirm that the accused person, through his agents, EACC and now this has been reported and is captured under annexure number R38. Italian police station. R38. PR38. And it's a PR38. We have a list photographs of security vehicles.
With your kind permission, I wish to raise an objection. And my objection now is founded on section 106B of the Evidence Act.
that is your name.
Release of your counsel first accused. Section 106.
Minutes. Based on
Section 106B
on electronic evidence.
on electronic evidence.
You get it time.
No, I'm not raising an objection because it's highly required.
You get your time, get it.
We have a next
I want to conclude the direction for us.
This will release a series of photographs. Weapons RR1 to RR37.
1, 2,
RR37. These photographs depict vehicles for the ACC, National Police Service, that were vandalized at the residence of the accused person. Yesterday, when the officers were executing the movement, execution the movement, that is, doing research pursuant to the series application E716
This legal application number
E716 of medical price. That is able to involve photographs are free to with the brief to ACH 046
come again
046 Africa development. When the photographs are ready to follow, to reach ACP 62H. What is the test of interfering with witnesses? It is not beyond reasonable doubt. The test is this unreasonable prospect that is will take with the witnesses.
the test is
A reasonable prospect that the accused person will tamper with the witnesses and the evidence.
Perhaps, and I'm aware of the directions you have given about the temporal. Perhaps we need your guidance whether counsel can go outside the content of his affidavit and claim to bring averments that are not contained in the affidavit, because that will prejudice us in terms of our response. Because there is no averment in the affidavit that affects that the proposed witnesses are the subordinates of the government.
I'll give a guidance again. Whatever you pick along the way from both submissions, kindly bundle them together. Once you rise, I expect that you address all the issues in one sweep.
I'm wondering.
But let me record you first. Mr. Kuma, give me some time. I need to record his objection. How long more? I thought we were going to take 3 minutes. Now we are going to, will we sit here the whole day? Just off the cuff. How long more?
I'll take it, 3 minutes. Just summarize it.
10 minutes. Continue, Mr. Cook.
Yes, sir. I will repeat
So your
that
10 minutes.
we are submitting that once disclosure is done, the witnesses will be calling officers from the first accused. Those are the subordinates. I'll take the second name. It's a very important offense.
Sorry?
I got the second compelling reason.
Second.
When approval of the charge sheet, the amounts will appear cashly.
The amounts will appear.
Minimum, 1 million. After the deed, the owner will win this case. And we draw your attention to section 62(1). of the Act. 62(1) of the Act. In the event we succeed, that provision is very punitive.
In the event,
We succeed.
we is
The
the
DPP
DPP.
prosecutes this case. We get a conviction.
Be successful.
Yes. We will be moving to section 62, subsection 1. And now that the severity of corruption cases. We need a recipe for someone to interfere. We submit in the positive. Lastly, public safety. I've alluded Your Honor to what transpired yesterday. And I've alluded that investigations with regard to other cases are ongoing. Our submissions is that if we release the accused person today, what transpired yesterday will happen. And we are apprehensive that in the interest of justice, in order to protect the integrity of the criminal justice processes. That our obligations now, and at least for the court to have an independent opinion, a plea report be available. A plea report be available before this court and decide on this issue. That's the only.
Sorry, Your Honor. Just on the line that our prayer is that the first accused be denied that probably is the last sentence. Thank you.
Mr. Jero, in July, how many of you would like to plead this bill? I'll take it because I listed how many? Listed 11. Yes, and one number of us. So how many? Just to manage our expectations.
Because the issues are straightforward, Your Honor. But let me start by introducing Senior Counsel John Wimwa.
Good morning.
So we have an introduction. Then I will do this also, yeah? So that is let me be the first one to draft this.
I don't need to record them.
Let me at the outset state that the prosecution is causing unnecessary drama in an otherwise straightforward matter. And our focus at this point will be the rights of the accused person who remains innocent unless and until he is proven guilty. So no amount of reasoning. Yes. So no possible grounds can be advanced that can be directed at taking away the accused person's rights. That should be the starting point. And some cases, Your Honor, as a counsel was now practiced for 33 years. I get concerned for
how long is that?
33 years.
That is not for intimidation.
I'm sure Dr. Hamino is smiling at you. Actually, it's sad. Very sad.
Your Honor, when prosecution purports to teach this court the law, citing authority, citing sections, pointed out to deny that. Before we stand here and I'm certain that they will believe in what they're saying.
Sorry, Your Honor. I know the court warned us of decorum, but we plead, I am just 12 years in practice, we plead that senior Macharia doesn't get personal. We are just here for our cases. Anything that we do is not personal. So we plead with him to have mercy on us and just stick to his case without attacking us. Thank you.
Mr. Jalango, to record the objection.
There is a special reason, Mr. Njero, I did what I did to your side, so that we remain focused. So remain in that trajectory.
Absolutely. My plea is that we have mercy on the accused person. Let's not talk about mercy on the prosecution or media. We are outside. It is him who's left in custody. Now, Your Honor, I'll say this with tremendous respect. What we have here is warfare, which I urge you, Your Honor, to take judicial notice of, because we live in this country, we are interacting with social media, we know what is happening in our country today. And none of us can afford to shut our eyes from that. Independent agencies are being captured and being used to weaponize matters of justice. That's what lawfare is all about. Where you use legal processes to attain an ulterior objective, which is to harass political opponents. Sad, extremely sad. Your Honor, I'll make a confession to you. I was last in a criminal court defending somebody 20 years ago. But this matter made me extremely agitated, and I said, I will come back to the criminal court to defend someone. Not because of his status, because we can't allow a country to degenerate to a situation where the criminal justice system now be used to harass opponents. That's wrong. And we shouldn't allow it. Your Honor, I am one of the few lawyers who have had the advantage of having been part of independent agencies and also been in private practice. One of the few. And I know how things operate in those agencies. I was the first year of independent police oversight authority, and we had a lot of run-ins in the executive. Constant interference attempt to direct us on how to do our work, including by the current president when he was elected president. And this is factual. It's in public domain, it is known.
Mr. Njero,
I'll give the context. I'll give the context.
focus.
Yes, I'll give the context.
Focus here, Mr. Njero. A minute.
I'll give the context.
A minute, Mr. Njero. The focus here is the accused, the law, the constitution. You understand our parameters, if you like. There are some parameters I am unable to swim in. I may not be very able to swim in. But I can swim in the constitution, I can swim in the law, I can swim. That's why I can swim in submissions around those lines.
The reason I'm telling you that, Your Honor, so that I can go straight to the context,
Yes.
is that independent agencies will come here and pretend more often than not that they're doing their work independently. I'm telling you, as someone who has been in those agencies, that unless as an individual you have the wherewithal to resist and do your work correctly, very few money to do that. That's the context. I'm not here to talk about where I was.
Sorry, Your Honor.
It's just to indicate.
Sorry, Your Honor, we are forced to object once more on the question. The factual matrix that the very learned senior is giving us are things that, with respect, he cannot tell us from the past. We would believe him, and I know he's a very truthful man, but for us to believe what he's telling you to believe, let him give us an affidavit of those facts so that we're able to respond to those facts. Without that, we humbly plead again. We humbly plead that he gets back to the case and not tell us the other things that are factual and there's no affidavit. We plead with him. We understand that it's previously the commissioner, we understand. But let him get back to our case. Thank you.
To respond to that, look at the affidavit.
A minute, Mr. Njero. I complete the recording.
You're gonna,
Mr. Njero, your brief response, you are responding?
yes. If you look even at the affidavit, they've made general averments. To start with, problem number one, they serve us in an affidavit this morning. What time did they expect us to respond to that affidavit? You know what is the trick? That it is designed in a manner that will expect us to make an application for a journey so that we can file an affidavit. And in the meantime, the accused person continues languishing in custody. You know those tricks. Then the affidavit itself is marred with general averments. This is factual. They are talking about respondents agents, they are not naming which agents.
So just to be clear, you responding to the objection or you continue with your submission?
I'm responding
That I'm
to
clear.
He cannot say that I'm making general averments. Yet in his own affidavit, he has made very general averments that are in support of denial of bail. Then he expects that I shouldn't be able to respond to that. At least from the back. In the very least, that should be expected. They can't have a state and Egypt. In fact, we should be given more latitude because the subject of these proceedings is the rest of us are speaking here, and then we walk away. But this is the subject. That is the person we should focus on.
Give me time to give direction. somebody wish to write again, we focus on rural government. That is the issue of the table. Continue, Mr. Njeri.
Now, Your Honor, the accused person is somebody who has served this country for a long time, not just as a governor. Knowledge of who he is in the public domain, including very sensitive security agencies. And he also understands the law by his own right. He understands his obligations to the public security. Besides being a governor, elected governor of the country. What was so difficult was just someone to court, telling me to appear in court and such a thing. Why all the drama? Arresting the man and putting him in custody for this kind of charge. Well, it can only be for the sole purpose of punishing him. It can't be anything else. And it is that desire to continue punishing him that is driving the application for him to be denied bail. You cannot allow yourself to realize that objective. You can't. I have consistently seen the last line of defense of this country. The only one remaining, Your Honor, is the judiciary. And if judges and judicial officers allow rights of accused persons to be taken away, we have no country. None whatsoever. And let's not think that when you allow that trajectory, that anyone will be safe, including the prosecution itself. No one, I can tell you, Your Honor. We need to learn from history. So regardless of what happens here with these protracted submissions and responses and comments, Your Honor, I beg, do not fall under the trap of saying that you're going to write a ruling another day to be meted in this custody. Don't allow this man to remain in custody. He's already been punished enough by being put in custody, even for that one night, when he could have been summoned to appear in court and he never appeared. One of my colleagues here will speak about the facts, then the chaser, but I can tell you, Your Honor, this alleged dysfunction that is being talked about, the accused was in Nairobi. Whatever is alleged to have happened was in Italy. How do you start connecting him to something that is happening hundreds of miles away when he was in the office of EACC? How? So I'll allow my colleagues to say something, but I'll end by saying this. The reality of our times is that between now and 2027, these are the kind of things you're going to see continuously. Lawfare, use of the criminal justice system to intimidate and harass opponents.
Your Honor, I once again plead with you, do not fall into that trap. I'm confident you will not do it.
Thank you. Thank you, Your Honor. Briefly, just give me the last aspect.
You can continue, Mr. Jiru.
Your Honor, just to associate myself with the submissions made by Milimani Senior, and to draw your attention to the content of the charge sheet, from where you will be able to drive the mischief. And the accused person is carrying.
Slower. Pause after every sentence. The accused person.
It's not surprising that the accused person is charged before you with another person, Wafula Masungo, who is not before you. This is not by coincidence. It is not that Wafula's whereabouts is not known. It's because, Your Honor, the state was in a hurry to perpetrate this mischief. In normal circumstances, Your Honor, such proceedings would not have commenced. When we sought for explanation, Your Honor, Milimani Senior indicated that he was seeking summons. It's the same mischief, Your Honor. When we sought for clarification from the prosecution, the opposition, Your Honor, was that you will seek summons. And the nature of the summons was not indicated to you. That is to say, Your Honor, therefore the application for you to deny bail must be read in light of that mischief. That other than pursuing public interests as dictated by Section 4 and 5 of the ODP Act, the ODPP is equally pursuing other ulterior motives that are politically actuated.
And our apologies, passing to the elections, Your Honor, to direct the focus on the charge sheet. The council has anything. Pass on the elections.
Minute and recording is start.
The direction.
Minute, I'll give you the directions.
The director will focus on the charge sheet and the issues related to bail. The colleague is submitting on a fact. Unless he has evidence as to what he wants to speak about, we will ask him take the stand on the other side and we will read the evidence. So let me speak on bail. And that's what this person. We just want to give the motive to anybody unless they are willing to take the law.
Your response, Mr.
Your my response is contained in the affidavit filed by the ODPP. But it's not surprising, Your Honor, that the affidavit contains mere speculations. It has no tangible evidence that proves to the contrary of what I earlier submitted. If I was to proceed in response to the substantive application,
must give direction in the objection. I remind that once more, I belong to the law on bond and bail, to avoid instances which may persuade me to request the fact of being evidence from your end.
I am well
which will render you in a very awkward position.
I am well Your Honor, the affidavit contains mere speculations. There is no affirmation in the affidavit.
After every sentence,
and there is no affirmation in the affidavit that is linked to the charge sheet before you. The affirmations in the affidavits have no nexus with the charges before you. These are matters that are happening in other spaces, which none of us, neither the prosecution, nor the defense, nor the court, are privy to. That is to say, that to deny the accused person bail on account of presupposed investigations would be tantamount or will amount to violating his constitutional rights. And most importantly, the right to presumption of innocence and the right to liberty. The argument here that the intended witnesses are subordinates to the governor, the accused person, really is not contained anywhere in the affidavit. And the same does not amount to a compelling reason. And so to say, the argument that vehicles were destroyed by his agents when there is clear lack of evidence linking the so-called agency with the accused person, again is speculative. Has no probative value of whatsoever nature. same is not empirical, and there is no nexus between that affirmance with the affidavits and the accused person. And as such, that cannot be considered to be a compelling reason. More annoying is that the office of the ODPP, which is fully funded with the taxpayers' money, had no courtesy of proving the ownership of these vehicles. You know, the producer of the so-called annexures, for instance, will not tell you who is the registered owner of KBU 734Y. Again, from the same annexure, you will not tell who is the registered owner of KCH 046T. It will not tell you who is the registered owner of KAE 7-8F. And you're being invited to deny bail on that ground. Registration of motor vehicles is a legal process. It is guided by the Registration of Motor Vehicles Act. And if you are courteous enough, respectful to the process and the proceedings, and holding the values of the Constitution of accountability and transparency, they would have consulted the NTSA. I want you just to, as a pen off and invite my other friends, to draw your attention to the charge once again, that there is no charge that the government is facing that is linked to its office. There is no way in the charge sheet that says that the governor abused his office. There is no way in the charge sheet where there is a charge of conflict of interests. That is therefore to say, in the absence of such kind of overcharge, in the absence of evidence, the argument and the affirmance by the prosecution is not being believed. I was perplexed, Your Honor, in summary, when I heard my own friend Mr. David invite you to look at Article 50 in isolation of Article 25 in light again of Section 8 of the Magistrates Court Act. He invited you to hold that the only jurisdiction you have in that respect relates only to Section Article 25A and B. Curiously enough, and in the attempt to persuade you, he believes the presumption of innocence and the fair trial from Article 25. He tells you that Your Honor, that the presumption of innocence.
I need to stop.
So we can He tells you that the right to presumption of innocence under Article 50, as protected by Article 25, can be limited under Article 24. That's a fallacy. It's a fallacy, it's a misconception, it's committing injustice and defying our Constitution. compelling. If you look at the law, Blackstone's dictionary, it will give you as to what is deemed to be compelling. That thing must be a strong issue, it must be convincing, it must be legally justifiable. It must be, or it must have the effect of compromising the integrity of the proceedings. None such affirmance has been pleaded. No evidence produced. No law quoted. No case law referred to. Under such a one, the granting of bail to our client will not prejudice, will not compromise the integrity of the proceedings, will not affect the so-called pending investigations, be minded of Article 24 and be minded of the test therein. When can a right be limited? A right can only be limited if it is just reasonably justifiable in a democratic and an open society. I invite Mr. Jerry to guide us on who next. Thank you very much.
How long more?
We won't take more than 10 minutes.
10 minutes.
I also give you a case law.
So how long are you?
10 minutes.
10 minutes.
Another
effect?
This is we have 4 more, but they'll be very quick. I'll manage the situation.
Always remember, the court has also business. So if we submit here the whole day, we understand the application, right?
We understand.
So we cannot submit the whole day and expect magic. We should be reasonable, and they say, for a wise man, one sentence is absolutely. You don't need to give 100 sentences in circumstances where you can give 1 sentence. I think that broad guidance serves us right? Yes. So we don't need to talk, all of us. In fact, I expected Mr. Njeri to ground this. There is no need of all of us.
We are guided.
So this is Mr. Chesa. Mr. Chesa, I'll give you 5 minutes.
Very well. Donna, I want to start by raising an issue with the manner of arrest. Which manner violated Article 25A of the Constitution and Section 8 of the Magistrates Court Act gives you authority to inquire into these violations. What this court gave the EACC was search warrants, not search warrants. Which they abused
by literally breaking into the accused person's residence in Kitale and Nairobi, bumbling him into a police vehicle and detaining him at the Integrity Center offices. We hold that the arrest was barbaric, unlawful, and an affront to the dignity of the accused person. Your Honor, to deny bail, the High Court in Danson Mgunya and another, this is the Mombasa criminal case number 26 of 2008. The High Court said the prosecution must provide cogent, the term is cogent evidence and not mere allegations. To have been told through the affidavit of Mr. Ruto, he keeps referring to some ghost creatures called agents of the respondent. Agents of the respondent attacked ESCC vehicles. Agents of the respondent shouted at Integrity Center, and that's a very serious threat. They have not drawn the matrix to link Governor Natembeya to the so-called agents. Was it Governor Natembeya's wife? Were they governor's children? Were they his staff? There is no such evidence placed before you. And those who amount to rumors, and this court must not listen to them. The accused person, Your Honor, is a decorated career civil servant. He is the governor, government of Trans Nzoia County. He is a deputy party leader of one of the most progressive parties. In all this, he is not a lonely man. At the time, the so-called ghost agents were shouting at the Integrity Center buildings. The governor had been locked up in the police cells. He had no access to his phones. He he was only allowed one advocate. Mr. Simiyu, the rest of us were locked out. Jero was asked to get clearance for net escape. Jero was asked for clearance for net escape to access his client. At what stage the governor plan with the so-called agents to do the unimaginable things that the state is supporting? In Nairobi miscellaneous criminal application number 351 of 2016, in Nairobi miscellaneous application number 351 of 2016, the court said that the seriousness of the offense per se is not a ground to deny bail. At the time of arrest, 2 more minutes, Your Honor. 2 more minutes, if this court allows. That just have 2 case laws, and we can do that 1 case law.
If we can stick to the directions of the courts.
I understand you.
You've already done more than 10 minutes. I gave you 5. I closed my eye to say you're finishing on the 6th minute.
Okay, yes, 1 more. In that case, you recorded that the seriousness of the
I repeat, 1 word is enough.
Lastly,
I don't know why we get this temptation, that the more I speak, is the more I persuade. Sometimes it's counterproductive. Can I bring it to your attention?
Yes.
Sometimes it is counterproductive.
This last one, R versus Richard David Alden. R versus Richard David Alden.
Richard
David Alden. The High Court at Nairobi. Criminal case number 48 of 2016.
Second case. Just list them. I will look at that.
Very well. I think that was the last case, and that the person must demonstrate actual witness interference, not mere allegations.
Straight
Witness interference. Employees of the county government are retained by county service board and not the governor. Therefore, there is no relationship between the governor and the employees of the county government, save for CECs who are merely policy makers. That is all.
Your Honor, with your permission, Mr. Simiyu was to the accused person in the ACC. He only say 1 word. He follow your guidance. Mr. Simiyu. Your Honor, I take 2 minutes. And I'm addressing
Proceed, Mr.
Thank you, Your Honor. Your Honor, number 1, I just want to write on what Mr. Echesa has said. The accused person did not have capacity to direct. Did not have capacity to direct third parties to commit acts of vandalism. Your Honor, I have an inventory.
Slower. You need your 2 minutes. Let's take it slow.
Your Honor, I'm worried about my 2 minutes.
Your Honor, I do have an inventory. Yes, Your Honor, which will demonstrate to you that indeed, as at 6:30 a.m. yesterday, the accused person had lost his 2 phones. And of course, he was in custody. So he could not speak to third parties. So, Your Honor, the averment in the affidavits by Mr. Robert Rono is certainly not accurate. Number 2, Your Honor, the place where they went to conduct searches. Your Honor, I want to refer to the affidavit of Mr. Rono at paragraph 3, where Mr. Rono said that among other places, they went to accused persons Kitale Milimani residence. That is repeated at paragraph 4 and paragraph 5 and paragraph 6 of the affidavit. Now, Your Honor, juxtapose that to the order. The order that they received to search the accused's premises had the following residences. 1 is Rongai residence in Nairobi. 2 is a residence in a place called Kibomet.
Come again.
First is
Second
is a place called Kibomet. Kibomet. Third is Nairobi residence in Kileleshwa. Okay. So that, Your Honor, when you turn to the affidavit, and of course they are using paragraph 6 particularly to seek to deny the accused person bail, they are saying that the motor vehicles that are said to have been vandalized were vandalized when they were searching his Italian residence. Your Honor, looking at the order, which Your Honor you can have a look at, the Italian residence is not captured. It's not there. And therefore, Your Honor, we are appealing to that the evidence that has been annexed to the affidavit is illegally obtained. And we are not very sure that the pictures that are said to be connected to the accused person's phone are genuine. And Your Honor, to cover that, I would want to refer you to the Evidence Act, Section 106, capital B.
I refer you to SOPEC. I read it recently.
I yield.
Honest to records.
Thank you.
No, I'll try 3 minutes at max, and you stop to your time.
Be sure it is 3 minutes.
Stop there. The first point, Your Honor, is just to raise point.
Now, I expect you start with what you wanted to raise.
Yes, that's what I'm addressing. Your Section 106 Appendix B of the Evidence Act is very clear in the manner in which electronic evidence is used. There is no certificate of electronic evidence annexing those pictorials. By dint of that section alone, there is no evidence in support of the bare allegations in the affidavit. There is no basis to even advance now any compelling.
Slow. Let me remind you. The applications contained in the
and the absence of the electronic certificate, the annexures are inadmissible and the court should expand them. In their absence, there is no evidence brought to court to support the opposition to bail. Finally, Your Honor, you are told that this court cannot interpret the Constitution. Section 3 of the Judicature Act lists the sources of law in Kenya that this court is called upon to apply. This court can apply the Constitution, including the Bill of Rights. When we say the court to apply Article 49, to apply Article 50, we are asking the court to apply it in the ordinary course of the court's duty. We are not asking for interpretation. Last point. Everything remaining constant, the right to bail is constitutional. And the purpose of giving terms is to compel attendance. The subject of the proceedings is now a warden of the courts, not a warden of the state. Bail and bond or pre-hearing detention should never be used as a basis to punish an accused person who is still presumed to be innocent. And I urge Your Honor to so consider this accused person as its warden that will attend to court as and when this court requires it. Thank you.
Mr. Jerry, your last soldier. Is it your last or?
This one, then Dr. Amino.
Dr. Amino.
Thank you, Honor. I'll take only 2 minutes.
Professor, you said you were taking 2 minutes.
2.5 minutes. I'm here before you to demonstrate that what I did recently in my second PhD in criminal justice should be put in a maiden opening, and you are the first that I'm hearing before, so I'm very privileged. Secondly, I would like also to thank my former teacher, Sunil. I think he taught me very well, and that's why I've been proceeding all. Now, the point that I want to make is just 1 or 2. I would like this court to look at the whole history of the government and intergovernment officers calling themselves ESCC and their mandate. I would like to apply what we call strict scrutiny. Strict scrutiny test. Law, whereby the government raises its own legitimate expectation to validate it is incompetency. Incompetency is aligned to rights protected by the Constitution.
Come again?
Incompetency is aligned to rights which are fundamental and protected by the Constitution. If that was the case, then that law must be narrowly, and I mean narrowly tailored to serve a compelling interest. What is a compelling interest? I'm not going into that issue because my senior counsels before me have already spoken about that. how do we look into the classification of what the state has alleged? Classification, looking at the time of the search, the time of arrest, the time taken to drive, the accused, the miles involved in that journey, the manner in which the accused was transported, where the accused slept, presumably in this case a common floor, and how the accused was arraigned in court. Lastly, Your Honor, I may not understand, and please let the court make me understand, whether the arresting officer is the investigating officer and the judge, and is an evidence provider, provision of evidence through affidavit, which even if mandated by statute, and even if that statute contradicts the Constitution, in which case I believe it does, following the circumstances in court, then there is high potency of illiteracy in the judicial, in the government executive system. I rest my case. Thank you.
Professor, are you sure you want that to go to record?
I think it should, because I can substitute it.
Literacy in respect to...
Your Honor, what I mean by literacy is not literally academic, schooling, but experience. And if we are to do what we call discoveries in law, the kind of affidavit you have seen here raises issues that can only be raised on discovery.
But you're admitted yourself.
Thank you.
Thank you. Daktari, how long? I'm not even sure whether I will fix time for you.
I will be extremely brief, except I'm asking for one indulgence.
Yes.
I have my own friend Mr. Dubi. I always appear with him in the cases. He has got only one word he wants to tell you. Only one word.
Very well.
One word will take maybe 1 minute or less.
Very well. Continue.
First, please look at the charge sheet. Point 1, the persons named there are 2. The particulars refer to 1. It is impossible to tell which one will be, except for the use of the word government. So we don't know whether the fuller is for government or the volume is for government. The second point related to that is particulars in the charge sheet under the law. And I take it something that the court knows how to do that, right, and understand. Those particulars which are suggesting that he has committed an offense of corruption, of conflict of interest. The particulars of conflict of interest are not been indicated. So without the indication, that what you call the seriousness of compelling evidence is not there. If you look, sorry, we have that code, that was in this. If you look at count 2, the same problem of lack of particulars. So that there is no evidence that demonstrates the nexus between Mr. Natembeya and the brother. And the third count is relates to the manual we going to talk about. Lastly, and this is about the allegation of money in cars of the government. something I was told when I was being talked to the young parents when I was much younger. We were told monkey see, monkey do. When the government itself gets court orders, citizens have no reason to monkey see, monkey do. When government violates court orders, it is impossible for citizens to trust it. So nobody will trust that they are doing anything helpful. So the citizens are taking after the government. And very lastly, I do recall off the top of my head, the governor of Prosecution, who was charged with the blood of support. The court ordered that he should not go to the county government. So this issue of interference with subordinates, if there are any, but my colleague just every does not stand. The court has authority and discretion to give conditions that will ensure that the proceedings of this court are held in effect.
Thank you very much. Your Honor, I was very the first point I would like to make to you, respectfully, Your Honor, because several counsels or advocates have spoken, they have made submission. I would respectfully urge that before you write a ruling, identical ruling, it is very necessary to guide this nation. You release the governor and you tell the audience that a written ruling will be delivered. Your Honor, this has always been done by the Court of Appeal, by the High Court. This has always been done by the Court of Appeal.
This one?
Giving reasons later.
Yes.
Has always been done by the Court of Appeal, the High Court, and recently even by the Supreme Court. So I urge you respectfully that before you rise this morning, you make an order that the governor is released forthwith and you deliver the ruling later. I also urge you very, very respectfully, Your Honor, that we will not free fall. The governor will go nowhere. We all know it. He lives in this country. He has rendered sterling services to the nation. And there's no way you can leave Kenya for another country. Give him a free fall. And you will also be educating certain people and certain people that the criminal law of the country must not be abused.
Slower, Dr. slower.
Your Honor, I'm saying to you respectfully that you make an order before you rise.
Sorry, that I scored and it's okay.
That the governor is be released on a free bond and you will give your reasons much later. Your Honor, permit me to continue.
Continue.
Your Honor, I'm a child born in the colonial days.
You're a child?
Born in the colonial days.
Colonial days.
I'm a child who received education in colonial institutions. I'm a child who read colonial literature of sociology, anthropology, philosophy, when you had terms like the African mind, how the African thinks and so on, from the colonial. There's one thing I can make you very clear. The criminal law of Kenya has always been abused. It has always been abused by those in power. It was abused It was abused during the Kenyatta state. It was abused considerably during Mutembei state. The only president that can put in a word in his favor is Mwai Kibaki. The criminal law was not abused during Kibaki's reign.
I think the statement is home, Daktari. The statement is home.
Oh, thank you very much, Your Honor. Now, Your Honor, permit me to go a little bit further. It is now being abused by the executive, by agents of the state. They have now taken over the criminal law of the country. They are abusing it. The rule of law which we thought was improving is now in ICU. And Your Honor, I'm urging you very respectfully that you can only get out of this quagmire with the boldness from the judiciary. Our judges have to be bold. Our magistrates have to be bold and state very clearly that the country will not be governed the way it is being governed at the moment. Your Honor, we live in this country. Every day I'm reading the Senate, I'm reading the Nation, I'm reading the Star, and I go even further to read any other newspapers outside this country. Clearly, Your Honor, what is emerging at the moment, that unless we arrest the situation, nobody will have politics in the country. The country could easily be classified as a banana republic. I filed a case recently, Your Honor, in court, the usual process, that we should refer certain matters now to the ICC.
Your Honor?
That we should refer certain matters of disappearances to the ICC. Let the International Criminal Court come in and see what it can do, that it can come.
Daktari, if we can deal with Mr. Natembeya first.
Yes. Your Honor, what is the judge? Can someone give me the judge? Your Honor, the judge you are given here, one can even pass in class. The first comes. The governor is supposed to have corruptly received the sum of shillings 1,127,900,000 shillings. You're not saying total that they took away billions of shillings. 1,127,900,000 shillings. Anybody with a critical mind like of John Hamilton can see that this is dishonest. It's nonsense. That you're bringing a governor of the state to the country because of that amount of money. That's on the first page. On the second page, 2,124,668. Hey, what is that? It's a full governor. 2,124,668. Sadly, Your Honor, the amount involved is 2,680,461. This is of a manual of Musumo. Your Honor, the criminal law is being abused. During the days of we will make one point clear. A constitution to be meaningful, it must develop something called contention. A constitution to be meaningful, it must develop in some cases something called convention. You would expect that a charge against a governor of the country, the director of public prosecution, would lead the entire file to satisfy himself that indeed a case has been made out before placing such a case before a criminal court. Your Honor, when did the DPP's plea was filed to satisfy himself that the case has been made out against himself? Having regard to what was being told, he was arrested with yesterday morning. When did the DPP read the entire file? And this is what I may say in favor of Charles and Johnson. He would read the entire file to satisfy himself that indeed a case has been made out against the government. A governor is no small man. A governor is not a messenger. A governor is a person who is ruling and governing millions of people. It is therefore not surprising that the people in his own area were mad to hear that their governor is being arrested. He's being brought into the country, being taken by the police. It's quite clear the file was not read at all. Your Honor, may I draw your attention to the fact that I shall, if I'm given the opportunity, I shall be conversing in some other quarters that the courts have no jurisdiction to contain the counts they have to that people. There's no jurisdiction at all. And I would refer you to Article 181 and Article 182 in the Constitution. If you read Articles 181 and 182, Your Honor, there is no provision that provides that a charge can be prepared against the governor. The way to deal with the governor is to use the impeachment proceedings that have been provided for in the Constitution. A governor cannot be arrested and charged the way things have been done. The Director of Prosecution himself, Your Honor, the DPP has no jurisdiction to make or to prepare charges against the government. So there is lack of jurisdiction. I'm making this point to strengthen my submission, Your Honor, that there is no case against the government. In this thing. Your Honor, one final question, or one final submission on the next year. Please don't misunderstand me at all. I've often thought that in a country like Kenya, strictly speaking, you do not have to be bright. You do not have to be bright in the law at all. What is required of a lawyer, what is required of a magistrate or a judicial officer is to be strong and to be courageous. The mind in your face that rise to the occasion and show those who are in power, who are in executive, that your powers can be challenged, that your powers can be reduced by the courts. And it is the courts that are in control of the country and nobody else at all. If we lose the control of the courts of the country, if we lose the power that the courts have, Kenya can easily and very shortly be classified as a banana republic. No wonder that the President of Tanzania said the word that he said about our country. The country has gone up. And we need young people like yourself, Your Honor, who have got power, to see what we can bring out and maintain the concept of rule of law in the country, independent of division, and to make sure that we can use the word and they borrow the word of our President, that let the executive keep its own day, not to get into other days. And currently, it is not doing so. Thank you, Your Honor. Asking to Honor. Yeah. Your program may say that when the Mahatma, I handled in some other quarters and so on.
Mahatma.
Yes, there is a book here I was referring to Impeachment in the Nigerian presidential system. That's where we have a lot of impeachment of governors and so on. And I will be borrowing words from this book. I'm just putting my learned friends from the prosecution notice that they order for this book.
What is the title?
Order for
Your Honor, I'm taking the title. It's impeachment in the Nigerian constitution. I assure the very learned senior that you have come.
I don't have impeachment of governors, Your Honor. And in Nigeria, you will see when members of the executive swearing that they would rather die than have such a government in power. Yes, some people, I'm sure, are swearing that they would rather die than see Governor Natembeya in power.
Very well. Mr. Njero, I think we are done.
Yes, we are done with.
Yes.
Our Father, with the Father, with profession, he has said it all. Okay, the governor, freeborn. At the very worst, some affordable cash flow. Let him not stay here an hour longer, so that we don't play in the hands of these tormentors. Let there be no conditions. This man has been elected by his people. He has committed no wrong until the case is proven, if at all. There was not even any affection in that effect. So let's not talk about conditions. In fact, that date, one of these expanded. Let him get his freehold or cash bill, let him leave. Even a street boy here will not be studying up in there. There's nowhere where he will go. We believe. We believe. You do the right thing. We have no doubt at all. I, for one, have no doubt. I know you are a good judicial officer. You believe in the rule of law. You understand the law. And even as we are doing all these things, you've appreciated it. I have no doubt that today the judgment will be will come. No conditions have been sought and should be behind me. Let man go and serve. He'll have his day in court.
Thank you very much.
Sorry, Your Honor, do we have a right to respond?
Of course, there are any objections. Mr. Owiti, together with who?
I'll just go alone. Most
I not specified.
Yes. Your Honor, start with the jurisdictional issue that has been raised by counsel, especially the very learned Dr. Amino, as whether or not this court properly has jurisdiction to entertain these charges. And whether or not the Director of Public Prosecutions had power to institute these charges.
Yes.
And that is related to reference to Articles 181 and 182 of the Constitution relating to vacancy in the office of a county governor in Kenya. I believe, I haven't made reference, but I believe that's the position. In brief responses, this court's jurisdiction to entertain anti-corruption matters is provided for under Section 4 of the Anti-Corruption and Economic Crimes Act. So that's a simple answer. Section 4 of the ASEC. ASEC is a law. Point of law is ASEC. So this court has jurisdiction. The Director of Public Prosecutions is vested with power to institute criminal proceedings against anyone before any court other than a court martial, Article 157, 6A of the Constitution. Allow me to make two corrections. My very good friend, Mr. Degwa, tells the court that there is no nexus between the affidavit and the charges, and if your record confirms what I also heard, that there is no such charge as conflict of interest, which is count number 1. I don't know whether counsel read the charge sheet. Count number 1 is conflict of interest. And not just that, count number 2. How could he have gotten that wrong? Conflict of interest. And it does not only mislead you on that. He says that the prosecution, on behalf of the prosecution, no law has been pleaded, no evidence has been produced, no case law has been referred to. I refer to Tom Chomley, it's case law in Kenya. I quoted Article 49(1)H. I quoted Section 123A. These are laws in Kenya. The second correction, Your Honor, my learned senior, Mr. Masharia, if I don't get that wrong, tells the court that the areas, the subject of the warrants issued on 18th of June were limited to 3. Kibomet and another one, it's on the record.
Sharia also.
Oh, Mr. Sibiu, I apologize. That's why I was not sure who's it. Your Honor, for those who have not given a copy of that warrant, it says, and any other part. Let me just read that so that I get it correct, so that I don't mislead the court. The warrants have been referred to, just below the areas listed. There is an any other office, business, and residential premises wherever they may be situated within the republic, unless we are reading different ones. So that even the search in Trans Nzoia was by law, was sanctioned by law. And then there's the related question as to whether the warrants issued could also be the basis of an arrest. That is the question asked by my learned friend and teacher, Mr. Echesa. Your Honor, this is a cognizable offense. Mr. Smith taught me this way back in 2011. For cognizable offenses, you don't need a warrant. So the arrest was proper by law. So the arrest was proper. The searches were proper. The defense has attempted to repudiate the charge sheet. Although they have gone around the corners, they're not coming strongly about it. But they seem to be questioning the propriety of the charge sheet, or rather the charges. There was no attempt to invite this court under Section 895 of the Criminal Procedure Code to reject the charges. Plea was taken. As it is, the charges are proper, including the particulars. And in compliance against with Section 214 of the CPC. But there is a smaller issue about the amounts. This is related to the charge as well. That a whole governor should not have been brought before you for amounts about 1 million or 2 million. You know, I I agree with Mr. Otieno that this court may not interpret but can apply. In the application of the constitutional provisions, Article 27, Sub-Article 4 obligates this court to ensure and promote an equal application of the law to everyone. Equal application of the law. Article 27, Sub-Article 4 of the Constitution. Before this court, you know, I've never had the privilege of appearing before you. And I'm sure my colleagues who have here have brought people with cases of soliciting a bribe. Some of them up to 3,000 or 5,000. They are Kenyans as well. So that the amount, the basis of the charge cannot be the basis to question whether or not the charges are proper or whether or not compelling reasons exist. I can confirm to this court that's a factual issue, but I can confirm to the court that the DPP, in fact, ascertained and satisfied himself that there were charges properly on the basis of which he could institute these proceedings before you. Now, in respect of Article 181 and 182 of the Constitution, we are not attempting to impeach the governor. The DPP has no such powers, legally or factually. But more importantly, whether or not denial of bail would amount to removal of a governor has been answered by the Supreme Court of the land in the case of Ferdinand Waititu versus Republic.
You know, he's raising new facts that were not part of address to the court.
That's a question of law, Senior.
No, it never came up, Your Honor. We perhaps need a very clear ruling on that particular objection, because that never arose in our submissions.
Dr. Aminu raised Article 181 and 182 and said that removal can only be by other parties, not the DPP or this court. That's what I'm answering. And again, because Mr. Ndegwa did not even know that conflict of interest was count one, he may have missed this as well. I withdraw.
If you have withdrawn, I wanted to clarify, but I scored me Dr. Minute saying something else.
Yes. It's going to mislead. Unfortunately, it's going to mislead the court.
Now that he has withdrawn, there is no need to clarify that point.
So, Your Honor, I
scored differently. Yes. So, now that you withdraw that point, I will not.
Most of like I've also withdrawn the arguments on 181 to I scored it differently. Back to the question of bond as I conclude. Page 19 of the Judiciary Bail and Bond Guidelines, at the very bottom in the footnotes, refers to a case of, let me just get it, Republic versus John Kahindi and two others, reported in the Kenya Law Report in 2010. Republic versus John Kahindi and two others, 2010 EKLR. It is at the footnotes of page 19 of the Judiciary Bail and Bond Guidelines. The import of that case, Your Honor, is that the prosecution does not need to avail an affidavit in opposition of bail. Anyone can confirm because the guidelines are available online.
The prosecution
does not need to avail an affidavit in support of an application for denial of bail. While other courts insist on it, not all courts insist on it. That's the import of that decision. It's cited at page 19 in the footnotes. The importance of that argument that you make is that even without an affidavit, compelling reasons can exist. And so that the argument by Mr. Otieno that if certain documents were removed or expanded, then there is no basis. If we can come without an affidavit, there is still basis. There's also the argument as regards saying that we are not, sorry, Your Honor.
We are now on your 12 minutes.
15 minutes and I'm done, Your Honor. I underestimated my abilities. I'm sorry.
You can't admit that. No, your pace, not abilities. I'm not doubting your abilities. You underestimated your pace.
Yes, yes.
A minute.
Continue, Mr. Owens.
Thank you. Your Honor, I was referring to, please Your Honor, just help me direct. What did I say last? Thank you.
Last you were attacking the challenge by Mr. Otieno.
All right, yes, thank you very much. So Mr. Otieno was of the effect that if there is no certificate under
that was concluded.
Then I can move to the next point. Your Honor, the other issue as regards bail, as I conclude, is that there is an admission from the defense, at least evidenced by Mr. Echesa and Dr. Haminwa. In Mr. Echesa's words, the first accused is a governor of a county. He is a deputy party leader, and he is not a lonely man. Verbatim, if I got it right. In the words of Dr. Haminwa,
I don't know whether Your Honor you misquoted in my presence, especially in terms of understanding.
You were not sure what you are objecting on. Is it points of law or what you say?
As in, you have quoted my statement here in my presence, yes. You clearly misunderstood it, and you want to go to the next person without clarifying the question.
Sorry, Your Honor, I have not interpreted what Mr. Echesa said. I have quoted it as I captured it. So the court can confirm that he said that the first accused is the governor of a county, is a deputy party leader, and is not a lonely man. I am quoting you verbatim. I may be wrong in my interpretation, but in hearing you, I can't be wrong.
Points of facts, points of law.
Your Honor, I'm coming to the point of law. I'm still quoting you. You cannot be the point of law. I am coming to the point of law. Yes, I'm still quoting so that I come to the point of law. Dr. Hamura, on the other hand, says that the people in the first accused area were mad yesterday as a result of his arrest. Those are two admissions as to and thirdly, I am reminded that my very good friend, senior Dr. Harunubi, mentioned that monkey see, monkey do, that the people have seen and are doing. The point of law we are making is that there is a likelihood of interference with witnesses. And that the influence of the first accused is admitted by his counsel on his behalf, and that it is not far-fetched that he would interfere with witnesses and investigations. Your Honor, clause 4.9 sub-clause E of the Judiciary Bail and Bond Policy Guidelines talks about likelihood. Yes, Your Honor.
You have said you need 30 minutes.
I am done. That is my last point. 4.9 sub-clause E of the Judiciary Bail and Bond Policy Guidelines talks about likelihood. It doesn't say certainty as proposed by Mr. Nego. If there is a likelihood because of that influence, there is a compelling reason you must deny bail. And standard of proof is on a balance of probabilities. I thank you for being patient with me. I am such a mouth. And we argue that we have established compelling reasons to deny the first accused bail. Thank you, Mr. Your Honor.
to add one of the points actually made. Honorable Jeremiah Kioni, Assessor Council, who wished to place him on record.
It's now almost 1. Taking it for So I will need a break to do a ruling on the matter. I possibly need almost 1. We take a lunch break. Take a lunch break. Though the issues are going into millions, I will try the best to do it in 1 hour. And Dr. Haminwa encouraged me to deliver decision, give reasons later. Unfortunately, we have not been facilitated that way by our procedures. For the Court of Appeal, for the Supreme Court, they are facilitated properly by dint of their own procedures. Or for the subordinate courts, that actually can give ground to suspect of my abilities and competence, which I do not wish. So we take a break. We resume at exactly 2 for the ruling. Much obliged.
Welcome back to watching Mutembei on this 20th day of May 2025. In studio I have Geoffrey Wandeto, who is the Member of Parliament for Tetu constituency. I also have Kabala Kile, Deputy Chairperson of PLP Party, People's Liberation Party, right? Great. Senator Veronica Maina, nominated Senator of the ADA Party, the governing party, and also Professor Maxwell Miyawa, International Development Law Scholar, and also teaches at the Kenya School of Law. Before we dive into the conversation, there's a story that that I want us to take a look at, which is about the High Court has suspended the vetting of nominees for IEBC chairperson and commissioners that was due next Monday. Justice Lawrence Mugambi issued the orders after lawyers representing petitioners Calvin Roy Omondi and Boniface Mwangi warned of the risk that the National Assembly may proceed to vet and approve the nominees in the absence of orders. The orders will remain in place until the 29th of May. Attorney General Dorcas Ruto, who filed a preliminary objection on the case, says the court lacks jurisdiction to hear the matter. IEBC nominees face another case filed by civil society outfit Operation Linda Jamii, who argued that the nominations are made without the necessary political consultation. The case is due for further direction on the 11th of June after petitioners serve respondents. Alright, and of course that is one of the stories that has been featured in the dailies on the 10th page of the Standard. They are talking about High Court House voting of Ruto 7 IEBC fixed by Parliament.
Yes, and that is related to reference in Article 181 and 182 of the Constitution relating to vacancy in the office of a county government in Kenya. I believe, having made reference that, I believe that's the position. In brief responses, this court's jurisdiction entertaining anti-corruption matters is provided for under Section 4 of the Anti-Corruption and Economic Crimes Act. So that's a simple answer. Section 4 of the ASEC. ASEC is a law. Don't talk about this ASEC. So this court has jurisdiction. The Director of Public Prosecutions is vested with power to institute criminal proceedings against anyone before any court other than a court martial. Article 157 6A of the Constitution. I want to make two corrections. A very good friend, Mr. Edward, tells the court that there is no nexus between the affidavit and the charges. And if the record confirms what I also heard, that there is no such charge as conflict of interest, which is count number 1. I don't know the council read the charge sheet. Count number 1 is conflict of interest. And not just that, count number 2. How could we have gotten that wrong? Conflict of interest. And it does not only mislead you on that. He says that the prosecution, on behalf of the prosecution, no law has been pleaded, no evidence has been produced, no case law has been referred to. I refer to John Chombi, case law in Kenya. I quoted Article 49(1)H. I quoted Section 123A. These are laws in Kenya. The second correction, Your Honor, I let it see Mr. Masharia, if I don't get that wrong, tells the court that the areas, the subject of the warrants issued on 18th of June were limited to 3, Kibomet and Madison, is on the record. Oh, Mr. Sibiu, I apologize, that's why I was not sure who's in. Your Honor, for those who are not given a copy of that warrant, it says and any other fact. Let me just read that so that I get it correct, so that I don't mislead the court. The warrant is being referred to just below the areas listed. There is an any other office, business, and residential premises wherever they may be situated within the republic, unless you are in different. So I think the search in Tanzania was by law, was sanctioned by law. But then there's the related question as to whether the warrants issued could also be the basis of an arrest. That is the question asked by one friend and teacher, Mr. Chesa. Your Honor, this is a cognizable offense. Mr. Smith brought me this way back in 2011. For cognizable offenses, you don't need a warrant. So the arrest was proper by law. So the arrest was proper. The searches were proper. The defense has attempted to repudiate the charge sheet. Although they have gone around the corners, they are not coming strongly about it. But they seem to be questioning the propriety of the charge sheet, or rather the charges. There was no attempt to invite this court under section 895 of the Criminal Procedure Code to reject the charges. Plea was taken. As it is, the charges are proper, including the particulars. And in compliance against with section 214 of the CPC. Well, but there is a smaller issue about the amounts. This is related to the charge as well. That a whole governor should not have been brought before you for amounts about 1 million or 2 million. I agree with Mr. Ochiero that this court may not interpret but can apply. In the application of the constitutional provisions, Article 27, Article 4 obligates this court to ensure and promote an equal application of the law to everyone. Equal application of the law. Article 27, Article 4 of the Constitution. Before this court, Your Honor, I've never had the privilege of appearing before you. I'm sure the colleagues who have here have brought people in cases of soliciting a bribe. Some of them up to 3,000 or 5,000. They are Kenyans as well. So that the amount, the basis of the charge cannot be the basis to question whether or not the charges are proper or whether or not compelling reasons exist. I can confirm this court as a factual issue. I can confirm to the court that the DPP in fact ascertained and satisfied himself that there were charges properly on the basis of which he would institute this proceedings before him. Well, in respect of Article 181 and 182 of the Constitution, we are not attempting to impeach the governor. The DPP has no such powers, legally or factually. But more importantly, whether or not denial of bail would amount to removal of a governor has been answered by the Supreme Court of the land in the case of Ferdinand Waititu versus Republic.
You are addressing new funds that are not part of this course.
That's a question of law, Senior.
never came up with, we perhaps need a very clear ruling on that particular objection, because I never have seen submissions.
Dr. Amin raised that for 181 and 182 to say that removal cannot be by other parties, not the DPP of this court. That's what I'm answering. And again, because Mr. Mbego, you don't even know that conflict of interest was count one, he may have missed this as well. I will know.
I wanted to clarify what I spoke with Dr. Miller saying something else.
Yes. It's going to mislead. Actually, it's going to mislead the community.
Now that you have withdrawn, there is no need to clarify that point.
So I
spoke differently. So now that you withdraw that point, I will not.
Most of like I've also withdrawn the arguments from 181 to my solid defense. So back to the question of bond as I conclude. Page 19 of the Judiciary Bail and Bond Guidelines, at the very bottom in the footnotes, refers to a case of, let's get it, Republic versus John Kahindi and two others, reported in the Kenya Law Report in 2010. Republic versus John Kahindi and two others, 2010 ELR. It is at the footnotes of page 19 of the Judiciary Bail and Bond Guidelines. The import of that case, Your Honor, is that the prosecution does not need to avail an affidavit in opposition of bail. Anyone can confirm because the guidelines are available online.
The prosecution
does not need to avail an affidavit in support of an application for denial of bail. While other courts insist on it, not all courts insist on it. That's the import of that decision. It's cited at page 19 in the footnotes. The importance of that argument that you made is that even without an affidavit, compelling evidence can exist. And so that the argument by Mr. Ochieng that if certain documents were removed or expanded, then there is no basis. If we can come without an affidavit, the same basis. There's also the argument as regards saying that we are not proof, so
we are now on your 12 minutes.
16 minutes and I'm done, Your Honor. I underestimated my abilities. I'm sorry.
You better look at it. No, your pace, not abilities. I'm not doubting your abilities. You have estimated your pace.
Yes, yes.
Minute. Continue, story.
Thank you. Your Honor, I was referring to, please don't just help me direct what you're saying.
Last you were attacking the challenge by Mr. Otieno.
Alright, yes, thank you very much. So Mr. Otieno was of the fact that if there is no certificate and that was concluded, then I can move to the next point. The other issue as regards bail, as I conclude, is that there is an admission from the defense, at least evidenced by Mr. Echesa and Dr. Amima. In Mr. Echesa's words, the first accused is a governor of a county. He is a deputy party leader. And he is not a knowing man. Verbatim, if I got it right. In the words of Dr. Hamid,
I was sorted in my presence in terms of understanding.
you are not sure what you are objecting on, is it point of law or what you say?
As you have quoted my statement in my presence, you clearly misunderstood it and you want to go to the next person without helping the question.
Sorry, Your Honor, I have not interpreted what Mr. Echesa said. I have quoted it as I captured it. So the court can confirm that he said that the first accused is the governor of a county, is a deputy party leader, and is not an only man. I am quoting you about I mean, wrong in my interpretation, but hearing you, I have given some facts. You know, I'm coming to the point of law. I'm still quoting you. You cannot be the point of law. I come to the point of law. Yes, I'm still quoting so that I come to the point of law. Dr. Hamura on the other hand says that the people in the first accused area were mad yesterday as a result of his arrest. Those are two admissions as to and thirdly, I am reminded that my very good friend, senior Dr. Herman, mentioned that money is seen, money good, that the people have seen and are doing. The point of law we're making is that there is a likelihood of interference with witnesses. And that the influence of the first accused is admitted by his counsel on his behalf, and that it's not far-fetched that he will interfere with witnesses and investigations. Your Honor, clause 4.9 subclause P of the Judicial and Police Guidance talks about likelihood. Mr. Whips. Yes, sir. Do you have it? You need that? I am done. That's my last point. 4.9 subclause E of the Judicial and Police Guidance talks about likelihood. It doesn't say certainty as proposed by Mr. Medwo. If there is a likelihood because of that influence, there is a compelling reason you must deny them. And standard of proof is on a balance of probabilities. I thank you for being patient with me. I am such a mountain, and we urge you that we have established compelling reasons to deny the first accused. Thank you, Mr. Honor.
One of the points that you made. Jeremiah Kion, Assessor of Council, who lives in America.
It's now almost 1. Let me eat So I will need a break to do a ruling on the matter. I possibly need
the opposition was that the 6 sons and the nature of the summons was not indicated to you. That is to say, Your Honor, therefore the application for youth management must be made in light of that issue. That other than the same public interests as indicated by section 4 and 5 of the ODB Act. The ODB is legal as seen under ulterior motive that are politically active.
Passing to the next issue, to the next focus, and the justice, the council has passing to the elections.
Military academy start.
The election.
I'll give you the election. Start with the
Directed with focus on the classic and the issues related to them. The committee is submitted on a fact. The rest who has evidence as what he wants to speak about them, will not see. Take the stand on the other side and then the limitations. The evidence will come to date. That's what is possible. That's what we feel so much in the less. The
response is zero.
The response is contained in the affidavit filed by the ODB. It so suffices, Your Honor, that the affidavit contains mere speculations. It has no tangible evidence that proves to the contrary of what the evidence submitted. Proceeding in response to the substantive application.
Must be direction and objection.
I remind that once more, I belong to the law and God and death. Avoid instances which may persuade me to request the fact and the evidence from your end. I am wishing to render you in a very bad position.
I will not. The affidavit contains no stipulations. There is no affirmance.
After every sentence,
and there is no environment in the affidavit that is linked to the charge sheet before you. The environments in the affidavits have no nexus with the charges before you. These are not as
which none of us, neither the prosecution, nor the defense, nor the court, are privy to. And it's true that we deny the legitimacy of bail on account of infamous investigations would be tantamount to an amount violating the sensational rights. And most importantly, the right to presumption of innocence and the right to liberty. The argument that the intended witnesses are subordinates to the government, the accused person, really is not contained in the affidavits. And the same does not amount to a compelling reason. And so saying, making the videos of the story by his agents, when there is clear lack of evidence linking the so-called agency in the case of and really speculative, has no objective value or whatsoever nature. The same is not empirical, and there is no nexus between that environments, the affidavits, and the accused person. And as such, that cannot be considered to be a compelling reason. More and more, in the office of the UDP, which is fully funded with the taxpayers' money, have no capacity of proving the ownership of these vehicles. We are the coalition of the so-called amnestias. For instance, we don't tell you the registered owner of ADU 7.4Y. Again, from the same amnesty, we don't tell you the registered owner of KCH 046G. It will not tell you the registered owner of AAE 7 and 8F. And you will be invited to find help on that ground. The registration of motor vehicles is a legal process. It is guided by the Registration of Motor Vehicles Act. And we are courteous enough, respectful of the process and the proceedings, and upholding the values of the Constitution of accountability and transparency, they would have consulted the NGC. But let me just as a payoff and the defense, to bring the attention to the judge once again, there is no charge that the government is facing that is linked to its office. There is no way in the charge sheet that says that the government has its office. There is no way in the charge sheet where there is a charge of conflict of interest. Therefore, says, in the absence of such
reading of a judge, analysis of evidence, the argument and the affirmance that the prosecution is not being believed. As a question in summary, when I heard my own friends David invite you to look at Article 50 in isolation of Article 25 in lines away of Section 8 of the Constitution Act. He invited you to hold that the only division you have that respect relates only to Section Article 25 A and B. Seriously enough. And I think to say he believes the presumption is in the territory from Article 25. It tells you that the presumption of innocence.
I need to stop on him.
So he tells you that the right of presumption of innocence is Article 50 as contained by Article 25 can be limited and Article 24. That's a fallacy. It's a fallacy, it's a misconception, it's committing injustice and defining our Constitution. What is compelling? Black means dictionary, it will give you as to what is deemed to be compelling. That thing must be strong issue, must be convincing, it must be legally justifiable. It must be have the effects of compromising the integrity of the proceedings. Nice such awareness has been needed. No evidence produced, no law quoted, no reason in fact. Such the granting of bail to our clients will not prejudice, will not compromise the integrity of the proceedings, will not affect the so-called pending investigations, of Article 4 in the mandate of the testimony when can a right be limited. A right can only be limited if it is just reasonably justifiable in a democratic and orderly society. I invite Mr. Jalango to guide us on this. Thank you.
Now, what is? How long?
We will take more than 10 minutes. 10 minutes. I also give you a case of
So, how long are you?
Just 10 minutes.
10 minutes.
And
Always remember, the boat has also business. So if we submit here the whole day, we understand the application, right? We understand. So we cannot submit the whole day and expect magic. We should be reasonable, and they say, for a wise man, one sentence is absolute. You don't need to give 100 sentences in circumstances where you can give one sentence. I think that broad line that serves us right? Yes. So you don't need to talk all of us. In fact, I expected Mr. Neil to ground this. There is no need of all of us. So this is Chesa, give it 5 minutes.
See very well. I want to start by raising an issue with man of arrest, which manner violated Article 25A of the Constitution and Section 8 of the Magistrates Court Act gives the authority to require illegal reservations. What this court did with EACC was such warrants. What? Such warrants? Would be abused by literally breaking into the accused person's residence in Italy and Nairobi, bumping into a police vehicle and detaining at the Integrity Center offices. We know that the arrest was sporadic, unlawful, and an affront to the dignity of the accused person. If you are to remind you, the High Court in Johnson, Ngunyi, and another. This is the Mombasa criminal case number 26 of 2008. The High Court said the prosecution must provide cogent, the term is cogent evidence and not mere allegations. You have been told through the affidavit of Mr. Ruto, he keeps referring to some ghost creatures so-called agents of the respondent. Agents of the respondent are characteristics vehicles. Agents of the respondent shouted at Mutembei Center, and that's a very serious threat. They cannot get the matrix to link Governor Natembeya to the so-called agents. Was it Governor Natembeya's zone? Were they run as children? Were they his staff? There is no such evidence placed before you. And those who are around rumors, and this court must not listen to them. This person, Honor, is a decorated career civil servant. He is the governor, government of Transfer County. He is a deputy party leader of one of the most progressive parties. In all this, he is not a young man. At the time, the so-called ghost agents were shouting at the Integrity Center because the governor had been locked up in the police cells. He had no access to his phones. He was only allowed one advocate, Mr. Similu. The rest of us were locked out. Jail was asked to get clearance for medicine. Jail was asked to get clearance for medicine to access his land. At what stage the governor plan with the so-called agents to do the unimaginable things that the state is supporting. In the only miscellaneous criminal application number 3/2016, in the miscellaneous application number 351 of 2016, the court said but the seriousness of the offense per se is not a ground to deny bail. At the time of arrest, two moments, if this was the best approaches and we can do that one easy.
If we can stick to the directions of the courts.
Yes, I understand you.
You've already done what the
10 minutes.
I gave you 5. I lost by 5, so you're finishing on the 6th minute.
Well, yes, one more. In that case, you recorded that the seriousness.
I repeat, one word is enough. I don't know why we get this temptation, but the more I speak, is the more I pursue. Sometimes it's counterproductive. Can I bring it to your attention?
Yes.
Sometimes it is counterproductive.
This Muslim, R versus Richard David Alden. R versus Richard David Alden.
Richard
David Alden.
Wakili tumefanya submission tunasoma nini? Wakati hata submission kwanza this one. Hiyo ni jambo JP. Huyu. JP. Hurumia kidogo. You are good to me. You are good to me. Sasa nyinyi mmejaa hapa. Excuse me.
Hujapiga sasa hivi? Sasa hivi. Hello? We don't have Kusaidia kadi yangu.
I know you will. My duty and sole obligation is to set us up. That is an obligation. And that's a political opinion. It's not an opinion, it's a duty. It's a duty. It's an obligation to every patriotic Kenyan. The time comes and I must but the time comes and I must
yako unachajia haishi moto ama iko connected.
Zilienda nyuma pamoja kuja ikaenda umetumia hii mzee.
Usiandikia namba yake nitumia link yake.
Iko busy. Kuongea.
Yes, with the defense at one point. But when I
Quorum is as before.
That's correct.
I want to apologize for, just like Mr. Witty, I underestimated my case. I tried using one finger. My professor was a poet. This is a summary of the ruling. Of course, we know the background of the matter. I will not set out the background. Through learned counsel Mr. Witty and Mr. Akula, the state proposed release of the first accused on bond of bail, citing grounds set out in the affidavit sworn on 19 May 2025 by the forensic investigator of ESCC, Mr. Robert Roman, which for purposes of this application were clustered into 3 grounds. First, it was submitted that the first accused is likely to interfere with witnesses. Second, it was submitted that the public safety dictates that the first accused is denied bail or bond. Third, it was submitted that the severity of the offenses justify denial of bail or bond. Through his advocates, led by Mr. Mashari and Jeru, the first accused sought to be released on free bond and or reasonable bail and or bond, arguing that the evidence placed before the court is insufficient to make the cut for compelling reasons. Owing to the constraints of time, the submissions of learned prosecution counsel Mr. Ombati, Mr. Witty, and Mr. Akula, representing the state as captured in the court record, are incorporated into this ruling, as if they are set out herein verbatim seriatim. Similarly, dictated by the same reason, the submissions of learned counsel representing the first accused, namely Mr. Mashari and Jeru, Mr. Njiru, Mr. Echesa, Mr. Simiu, Professor Wajakoya, Mr. Nubi, and Dr. Haminwa, are also captured in the, as captured in the court record, are also incorporated into this ruling as if they are set out in the ruling verbatim seriatim. These scholars consider the grounds can be both in support and in opposition of bond and or bail in respect to the first accused. Gathering from the affidavit in opposition to bail, this submissions canvassed by all learned counsel, 3 questions for dissemination have commended themselves as follows. First, whether the state has made a case to justify a decision of this court to deny the first accused bond and or bail. Second, whether the evidence which was gathered from the first accused's residence situated in Milimani area within Kitale was unlawfully obtained. Third, whether the constitutional rights of the first accused were violated. I will analyze each question in turn. Relating to the first question, I will summarize. I have discussed the history of bail and bond in Kenya, the Republic of Kenya, both colonial and post-colonial. That led me to the Constitution of Kenya 2010, in particular Article 49, 1H of the Constitution, which is at the center of this application. I also discussed the provisions of sections 123 and 123 capital A of the Criminal Procedure Code. In particular, in actualizing Article 49(1)H, the Statute Law Miscellaneous Amendments Act 2014, number 18 of 2014, dated 24th November 2014, introduced into the Criminal Procedure Code Section 123A, which stipulates as follows: exception to right to bail. Subsection 1 subject to Article 49(1)(h) of the Constitution, and notwithstanding Section 123, in making a decision on bail and bond, the court shall have regard to all the relevant circumstances, and in particular, A, the nature or seriousness of the offense, B, the character, antecedents, associations, and community ties of the accused person, C, the defendant's record in respect of the fulfillment of obligations and previous grants of bail, and D, the strength of the evidence of his having committed the offense. Subsection 2 provides that a person who is arrested or charged with any offense shall be granted bail unless the court is satisfied that the person, A, has previously been granted bail and has failed to surrender to custody, and that if released on bail, into brackets, whether or not subject to conditions, it is likely that he would fail to surrender to custody. And B, the last condition, should be kept in custody for his own protection. In my mind, therefore, I entertain no doubt that any accused post the 2010 Constitution, notwithstanding the nature of the offense, is entitled to release on bond or bail, save where the DPP adduces facts and evidence constituting compelling reasons. The prominent divergency from the repealed Constitution is that the Constitution of Kenya 2010 now enjoins the court to strike a balance between the rights of the accused and those of the victims. I'm skipping some parts for your own reading. I have cited several decisions in line of that principle of a delicate balance between the competing rights. I've also considered the bail and bond policy guidelines of March 2015 and the construction assigned to how that policy has been construed by the superior courts, and in particular in Republic against Richard David Alden, reported in 2016 in the electronic version of the Kenya Law Reports. So I have also discussed diverse considerations in decisional law and diverse grounds in decisional law, most of which I will not read word after another. I will skip to the standard of proof. What then is the standard of proof? And how should compelling reasons be presented? In Java, against the Republic, in 1973 staff reports, in page 39, to observe that in opposing applications for bond, that is the Court of Appeals saying, based on grounds set out herein above, it is not enough for the prosecution to make their objections and insinuations. It was underlined that the same objections should demonstrate how release of the accused will be detrimental to justice by being supported by cogent reasons and facts. The decision to grant or refuse bail is only based on probabilities and not certainties. The standard of proof, therefore, is on a balance of probabilities, as opposed to the standard applicable in proving criminal charges. Having carefully considered each of the three grounds advanced in support of the objection to bail on bond in the context of the aforementioned discussed statutory considerations, grounds plus the decisional law considerations and grounds, on a balance of probability, in summary, although palpable fear was apparent, unfortunately the evidence presented failed to generate persuasion in my mind that it is more probable than not that the first accused is likely to interfere with witnesses. I further find the grounds of public safety and severity of the offences unpersuasive. In any event, gathering from the foregoing principles, the apprehension of the state of interference of witnesses and exhibits can be addressed using alternative means in view of the drastic step of denial of bond. Wherefore, this court reaches a conclusion that the state has failed to present compelling reasons to deny the first. Question B, whether the evidence which was gathered from the first accused's residence located in the Milimani area within Rebuttal was unlawfully obtained. Concerning this question, intentionally so, this court refrains from determining it at this stage on account of the fact that the nature of the question commends itself for determination by the trial court. Question C, whether the constitutional rights of the first accused were violated. Concerning this question, this court too refrains from determining it now on account of the fact that it was raised informally from the bar in a manner stripping it of the manner of pleading such questions as enunciated in the locus classicus and Arita Karimu case, a principle which has since received adoration and affirmation by the Supreme Court of Kenya in a litany of cases. Further, this is a question capable of determination in another forum, separate. Disposition. Consequently, in regard to bond and bail, this court directs and orders as follows. A. That pursuant to Article 49, Clause 1, Paragraph H of the Constitution, and Section 123, Capital A, Subsection 1 of the Criminal Procedure Code, the first accused is admitted to both cash bail and bond. B. That the first accused shall be released upon executing a bond of Kenya shillings 1 million with one surety of the same amount. Alternatively, the first accused shall be released upon depositing cash bail in the sum of Kenya shillings 500,000 and providing two suitable contact persons whose particulars shall be captured by the registry, including copies of identity cards, their contacts, and other details that may be required by the registry. C. Upon release and while at large, and to address the apprehension raised by the state, the following conditions and restrictions shall apply. Roman 1. That the first accused undertakes not to interfere with witnesses and or evidence. Roman 2. In order to allow EACC to secure evidence and witnesses, if any, or if there is further evidence to be secured,
the first accused is prevented from going to his office at the county headquarters for a period of 60 days running from today. Roman 3. The first accused undertakes that he shall neither commit any offense nor interfere with the investigations nor threaten witnesses in relation to this matter. Roman 4. That in the event they are protected witnesses, the first accused undertakes not to flout the law and restrictions which govern protected witnesses. Roman 5. The first accused undertakes to appear before court as and when required. Roman 6. The first accused undertakes to arrive in the courtroom at least 15 minutes to the appointed time for mention of hearing unless exempted from attending court physically. Roman 7. That in the exceptional occasions where proceedings are conducted virtually, upon directions of the court, which will issue from time to time, the first accused undertakes to join the virtual platform at least 15 minutes before the appointed time. Roman 8. That in case of bond, the proposed surety shall provide security acceptable to the court upon verification thereof. Roman 9. Roman 9 is joined with 8. It provides the kind of surety that is expected by the court. It's a long provision that can be read by yourselves. Roman 10. That all documents provided by the proposed surety as security in this regard shall be subject to verification by the investigation officer at the cost of the state. Roman 11. That the first accused is not permitted to exit Kenya except with the express permission of the court. And Roman 12. The first accused is warned against offending the sub judice rule. In this connection, except in the court proceedings to ensue, the first accused is warned against discussing in public, including in or with the media, the merits or otherwise of this case. B. That the first accused is hereby notified and accordingly undertakes that breach of any of the foregoing conditions shall attract consequences as prescribed by law, including but not limited to cancellation of the bond of bail terms, with the attendant consequence of being held in remand prison until conclusion of the case. Finally, in compliance with Article 52G of the Constitution, the prosecution is directed to supply all documents upon which the state will place reliance to the defense before the next mentioned date. In this regard, the prosecution shall be deemed to have complied by doing the following. A. If any, tabulating the full list of prosecution witnesses, briefly indicating the nature of evidence each witness will present, unless the witness is protected, and the approximate time each witness is likely to take in examination in chief. B. If any, preparing a bundle of documents, binding them serially, with the exception of the bundle retained by the Director of Public Prosecutions for purposes of production in evidence, and tabulating the list of documents in the bundle, describing each document, paginating each serially, and indicating the corresponding number of pages for each document. And where only part of the document is relevant, highlighting the relevant part of the document. C. If the number of documents cannot fit one bundle, the prosecution is at liberty to serialize them in volumes. D. The prosecution is directed to serve the same list of witnesses and bound documents upon the accused or the accused's counsel, whichever is applicable, before the next mentioned date. E. The prosecution is further directed to share with the court the following: the tabulated list of witnesses and the tabulated list of documents only. F.
All copies of the tabulated list of witnesses and the state band of documents held by all parties shall be identical to the originals held by the state. Very finally, this matter is allocated to court number 4 for further directions, hearing, and determination. In this connection, there will be a mention before court number 4 on 3rd of June 2025 at 9:00 a.m. for pretrial directions.
Yes, we graciously take your leave and we want to appreciate your time. Secondly, Your Honor, we pray for summons for the second accused to report to EACC by tomorrow or the day after tomorrow. That is all, Your Honor.
Sorry, let me just take the opportunity to thank you for your patience and being able to produce a very detailed ruling within a very short period of time, which we are obliged about. We are grateful.
I also wish to thank you most profusely. I wish to thank you most profusely for the attention to details that you've given to the matter. I have never any doubt in my mind that you would arrive at the right decision. Two issues which I'll make reference to very briefly, conscious of the fact that I'm sure you're tired, you've spent more time than all of us combined together. Insofar as the office being secure, the office of the distinguished governor, it is our plea that whatever visits that are to be made by the EACC or the investigating team, it is only fair that proper notice are furnished and the counsel for the accused person is also present to avoid a situation whereby is prejudiced by whatever activities that may take place in that office. That is one. Secondly, Your Honor, and I say this with a lot of respect, I do not wish to cause drama. I am at a stage in life and in the profession where I prefer to deal with issues as opposed to drama. There's a lot of police officers who are already outside the court, and there's an indication that there could be an attempt again to rearrest the accused person to defeat the very purpose for which this bill has been granted. Consequently, we would wish to receive an undertaking from the prosecution, just as the undertakings have been made obligatory on the part of the accused person regarding how he is to conduct himself. We would also wish undertaking for it to be given in front of you that there is no intention at all to again away the accused person and take him to custody to defeat the purpose for which we applied for bail and which we granted orders after very elaborate submissions. And in the event they don't give that undertaking, it is our humble plea, Your Honor, because you can't grant orders that are in vain, that you exercise your discretion and extend that day to anticipatory bail to also cover any intended arrest, if at all. We are giving an undertaking. In fact, I'm giving a personal undertaking as an officer of this court and somebody who has practiced in these courts and also practiced in independent institutions, that if he is required at any given time, we will surrender. Nobody needs to go to knock at his door. Nobody needs to pounce on him as if he's a criminal for him to be brought to court. We bring him ourselves.
Thank you, Your Honor. Thank you very much for what you've done today. Is visible in the tenets of justice. In addition to what our lead team leader has said, I would like you to take into account or to give directions to us to the custody of the office of the governor. The custody of the office of the governor should be secure and to be fair on both sides of the coin. Should you make a decision, we would like you to consider that we'll have a concurrent custody of the office of the governor, so that we do not give any doubts that may lead to the fruits of a poisonous tree, if I may make that in reference to the Miranda case of 1967, in that any evidence obtained unlawfully without justification will always be rendered unlawful as having been obtained through the fruits of exaggeration. Thank you, Your Honor.
Council, Your Honor, in relation to the 2 months and the office of the governor, Your Honor, bearing in mind that the governor's office is executed by the governor and the CECs, could you kind enough to give further directions, Your Honor, so that in the event the governor is needed to execute his constitutional mandate, then probably there will be a way of doing it other than that office is his office. And unless it has a branch, Your Honor, then it means for 2 months the governor is not able to work. And that goes against the Constitution, Your Honor, and against the people of this country. And thank you.
Finally, Your Honor, in respect to the same, permit me to address the court on the issue of where we find ourselves as a country in terms of budget cycle. We are in the budget cycle that affects both the national government and the county government.
Sorry. We need to understand if Mr. Njero is seeking a review of your decision so that we prepare to answer. Because we understood what was being done on the other side to be comments post the ruling. But the trajectory is taking appears to be intentional on you varying certain aspects of that. We need it to come out clearly so that we prepare, if that's the intention.
We leave it at that. We just restrict ourselves to the issue that I've raised, the 2 issues.
From your side, please, leading.
I'll go alone. Yes, I think just 3 minutes. This time I'm sure I have estimated properly. We are agreeable to notice being issued for the ESC when they go to access for propriety, so that the accused person may be represented the council. We are not agreeable, however, to what Professor Wajakoya is calling concurrent custody. I've never heard about that. The office has been characterized, at least from our end, as a scene of crime. Your orders capture the protection for both sides, that if the investigators are to access, the notice to be given so that counsel for the accused person is present to protect his rights. We are afraid, or rather I'm afraid, but I've shared with my colleagues, we cannot give an undertaking. You know, the role of the prosecutor is simply to institute an undertaking of proceedings. While I do, like I said, I have always had reason to believe Senior Macharia Njeru is a man of his word. But I do not have any basis, or I'm not blessed with the same information he has, that there may be an arrest after this. Secondly, arrests are done by investigative agencies. The ODP does not involve in arrests. So unfortunately, we can't give that undertaking, but we join in the hope that there is no arrest that happens. However, Your Honor, very importantly, should an arrest ensue on the basis of the same facts where the court has given a bond, then counsel are very aware that they can come back to you and give and seek appropriate orders. I'm not able to go into possible arrest for any other offense which I'm not aware of. Maybe Senior would have done better to add additional facts. But for his suspicion, we are unable to give an undertaking. We join him in the hope that there will be no arrest. But if the arrest is to happen, they know how to seek subsequent orders from the court, or even from the High Court if necessary. We are obliged. Thank you.
Now that you have made it clear on the first point that there is no objection, that we agree. And the second one, which is extremely important, we are in your hands, Your Honor. We do not want to live by hope. If there was the issue of hope, we would not even be where we are. So we are in your hands. Protect the first accused person. Protect the integrity of the order that you have granted. I've given an undertaking, and you say that whenever he is required, we will surrender him. And you can join me in that undertaking, both the first accused person and myself. So with that understanding, protect him, so that he is not again grabbed outside here, immediately we are outside this court.
Sorry, Your Honor, I don't know whether you, with any leave, give me the position to ask. Or do we understand Senior to also be asking for anticipatory bail of some form? I don't understand. If that is true, then you can respond to that question. You just need that clarification from him. If he's seeking
it as much.
Okay. It was an oversight that I didn't respond to that bit. My seniors reminded me. Can I just say a word on that? For anticipatory bail? That this court lacks jurisdiction to grant anticipatory bail. And even if this court had jurisdiction, you have no material before you. What you have is the truthfulness of Mr. Macharia, which is not founded on anything else. So, number one, the court lacks jurisdiction, but even if you had the jurisdiction, you have no material to grant bail. Thank you.
Your Honor, just to clarify, you cannot grant orders that are in vain. And we are officers of the court, and he said that the truth, no sort of proof that the truthfulness, then at the same time he withdraws that truthfulness by saying that it's no material. At the end of the day, you are a judicial officer with powers. You can exercise your discretion and ensure that again your orders are not abused. That's what we are asking.
I have considered issues. Upon the first request was from Mr. Mati, it is granted. The second accused, of course, serve the summons latest by tomorrow, 10 a.m. The accused to attend court not later than 22nd of May 2025. Relating to the question of visiting the office at ESCC, the request is granted. Court directs that each time ESCC wishes to visit the office of the first accused, they shall be accompanied by counsel on record for the first accused. Concerning the issue raised by the Honorable Manzo, any order issued restricting a right traditionally is construed strictly in the narrow sense drafted. So, denying the first accused access to his office for a period of 60 days does not at all stop the first accused from working. The denial to access the office means that the physical office, and that is why it's specified in the headquarters for the period of 60 days. That is what it means. So that office, if ESCC after 60 days they're like, we are done, then if there are issues, the court will be approached. If there are no issues, of course, that is the end of that restriction. I did not wish to give permanent restriction as yet. However, if other courts in the future think that there is need for permanent restriction, that I'm not in control. What other issue? I think I've clarified that issue enough.
Potential arrest.
For potential arrest, unfortunately, all counsel seated here understand my limitations. Before I understand, you understand. So I think the High Court is just across the road. We can approach it for if there is a problem, but I want to believe we are not acting that way. I am just expressing a feeling. I don't think we want to act that way. The less I say about that, the better. Allow me to stop there.
Much obliged. Much obliged.
And the copies are seen a few times. Copies will be available in a matter of about 8 minutes. Copies of the ruling. So wait for the copies.
that stop
Quorum is as before.
That's correct.
I want to apologize for, just like Mr. Witty, I underestimated my place. I tried using one finger. Like Professor Wajakoya.
This is a summary of the ruling. Of course, we know the background of the matter. I will not set out the background. Government Council, Mr. Witty and Mr. Akula, the state proposed release of the first accused on bond of bail, citing grounds set out in the affidavit sworn on 19th May 2025 by the forensic investigator of ESCC, Mr. Robert Roman, which for purposes of this application were clustered into three grounds. First, it was submitted the first accused is likely to interfere with witnesses. Second, was admitted that the public safety dictates that the first accused is denied bail or bond. Third, it was submitted also the severity of the offenses justify denial of bail or bond. Through his advocates, led by Mr. Mashari and Jeru, first accused sought to be released on free bond and or reasonable bail and or bond, arguing that the evidence placed before the court is insufficient to make the cut for competitive reasons. Owing to the constraints of time, the submissions of learned prosecution counsel Mr. Ombati, Mr. Witty, and Mr. Akula, representing the state as captured in the court record, are incorporated into this ruling, as if they are set out herein verbatim, seriatim. Similarly, dictated by the same reason, the submissions of learned counsel representing the first accused, namely Mr. Mashari and Jeru, Mr. Njiru, Mr. Echesa, Mr. Simiu, Professor Wajakoya, Mr. Nubi, and Dr. Havima, are also captured in the, as captured in the court record, are also incorporated into this ruling as if they are set out in the ruling verbatim seriatim. These various considered grounds can be both in support and in opposition of bond and all bail in respect to the first accused. Gathering from the affidavit in opposition to bail, this submissions canvassed by all learned counsel, 3 questions for dissemination have commended themselves as follows. First, whether the state has made a case to justify a decision of this court to deny the first accused bond and or bail. Second, whether the evidence which was gathered from the first accused residence situated in the Milimani area within Kitale was unlawfully obtained. And third, whether the constitutional rights of the first accused were violated. I will analyze each question in turn. Relating to the first question, I will summarize. I have discussed the history of bail and bond in Kenya, the Republic of Kenya, both colonial and post-colonial. That led me to the Constitution of Kenya 2010, in particular Article 49, 1H of the Constitution, which is at the center of this application. I also discussed the provisions of sections 123 and 123 capital A of the Criminal Procedure Code. In particular, in actualizing Article 49 1H, the statute law miscellaneous amendments Act 2014, number 18 of 2014, dated 24th November 2014, introduced into the Criminal Procedure Code Section 123A, which stipulates as follows. Exception to right to bail. Subsection 1. Subject to Article 49 1H of the Constitution, and notwithstanding Section 123, in making a decision on bail and bond, the court shall have regard to all the relevant circumstances, and in particular, A, the nature or seriousness of the offense, B, the character, antecedents, associations, and community ties of the accused person, C, the defendant's record in respect of the fulfillment of obligations and individual's grants of bail, and D, the strength of the evidence of his having committed the offense. Subsection 2 provides that a person who is arrested or charged with any offense shall be granted bail unless the court is satisfied that the person, A, has previously been granted bail and has failed to surrender to custody, and that if released on bail, into brackets, whether or not subject to conditions, it is likely that he will fail to surrender to custody. And B, the last condition, should be kept in custody for his own protection. In my mind, therefore, I entertain no doubt that any accused post the 2010 Constitution, notwithstanding the nature of the offense, is entitled to release on bond of bail, save where the DPP adduces facts and evidence constituting compelling reasons. The prominent divergency from the repealed Constitution is that the Constitution of Kenya 2010 now enjoins the court to strike a balance between the rights of the accused and those of the victims. I'm skipping some parts for your own reading. I have cited several divisions in line of that principle of a delicate balance between the competing rights. I've also considered the bail and bond policy guidelines of March 2015 and the construction assigned to how that policy has been construed by the superior courts, and in particular in Republic against Richard David Alden, reported in 2016 in the electronic version of the Kenya Law Reports. So I have also discussed diverse considerations in decisional law and diverse grounds in decisional law, most of which I will not read word after another. I will skip to the standard of proof. What then is the standard of proof? And how should compelling reasons be presented? In Java, against the Republic, in 1973 staff reports, it said 39, to observe that in opposing applications for bond, that is the Court of Appeals saying, based on grounds set out here in above, it is not enough for the prosecution to make their objections and insinuations. It was underlined that the same objections should demonstrate how release of the accused will be detrimental to justice by being supported by cogent reasons and facts. The decision to grant or refuse bail is only based on probabilities and not certainties. The standard of proof, therefore, is on a balance of probabilities, as opposed to the standard applicable in proving criminal charges. Having carefully considered each of the three grounds advanced in support of the objection to bail and bond in the context of the four discussed statutory considerations, grounds plus the decisional law considerations and grounds, on a balance of probability, in summary, although palpable fear was apparent, unfortunately the evidence presented failed to generate persuasion in my mind that it is more probable than not that the first accused is likely to interfere with witnesses. I further find the grounds of public safety and severity of the offences and persuasive. In any event, gathering from the foregoing principles, the apprehension of the state of interference of witnesses and exhibits can be addressed using alternative means in view of the drastic step of denial of bond of bail. Therefore, this court reaches a conclusion and the state has failed to present compelling reasons to deny the fact. Question B, whether the evidence which was gathered from the first accused's residence located in Milimani area within Kitale was unlawfully obtained. Concerning this question, intentionally so, this court refrains from determining it at this stage on account of the fact that the nature of the question commends itself for determination by the trial court. Question C, whether the constitutional rights of the first accused were violated. Concerning this question, this court too refrains from determining it now on account of the fact that it was raised informally from the bar in a manner stripping it of the manner of pleading such questions as enunciated in the locus classicus and Arita Karimu, a principle which has since received adoration and affirmation by the Supreme Court of Kenya in a liturgy of cases. Further, this is a question capable of determination in another forum, separate. Disposition. Consequently, in regard to bond and bail, this court directs and orders as follows. A. That pursuant to Article 49, Clause 1, Paragraph H of the Constitution, and Section 123, Capital A, Subsection 1 of the Criminal Procedure Code, the first accused is admitted to both cash bail and bond. B. That the first accused shall be released upon executing a bond of Kenya shillings 1 million with one surety of the same amount. Alternatively, the first accused shall be released upon depositing cash bail in the sum of Kenya shillings 500,000 and providing two suitable contact persons whose particulars shall be captured by the registry, including copies of identity cards, their contacts, and other details that may be required by the registry. C. Upon release and while at large, and to address the apprehension raised by the state, the following conditions and restrictions shall apply. Number 1. That the first accused undertakes not to interfere with witnesses and or evidence. Number 2. In order to allow EACC to secure evidence and witnesses, if any, or if there is further evidence to be secured, the first accused is prevented from going to his office at the county headquarters for a period of 60 days running from today. Number 3. And the first accused undertakes that he shall neither commit any offense nor interfere with the investigations nor threaten witnesses in relation to this matter. Number 4. That in the event they are protected witnesses, the first accused undertakes not to flout the law and restrictions which govern protected witnesses. Number 5. That the first accused undertakes to appear before court as and when required. 6. The first accused undertakes to arrive in the courtroom at least 15 minutes to the appointed time for mention of hearing unless exempted from attending court physically. 7. That in the exceptional occasions where proceedings are conducted virtually, upon directions of the court, which will issue from time to time, the first accused undertakes to join the virtual platform at least 15 minutes before the appointed time. 8. That in case of bond, the proposed surety shall provide security acceptable to the court upon verification thereof. 9. Roman 9 is joined with 8. It provides the kind of surety that is expected by the court. It's a long provision that can be read by yourselves. Roman 10, that all documents provided by the proposed surety as security in this regard shall be subject to verification by the investigation officer at the cost of the state. Roman 11, that the first accused is not permitted to exit Kenya except with the express permission of the court. And Roman 12, the first accused is one against offending a sub judice rule. In this connection, except in the court proceedings to ensue, the first accused is one against discussing in public, including in or with the media, the merits or otherwise of this case. B, that the first accused is hereby notified and accordingly undertakes that breach of any of the foregoing conditions shall attract consequences as prescribed by law, including but not limited to cancellation of the bond of interest, with the attendant consequence of being held in remand, prison, until conclusion of the case. Finally, in compliance with Article 52G of the Constitution, the prosecution is directed to supply all documents upon which the state will place reliance to the defense before the next initial date. In this regard, the prosecution shall be deemed to have complied by doing the following. A, is any tabulating the full list of prosecution witnesses, briefly indicating the nature of evidence each witness will present, unless the witness is protected, and the approximate time each witness is likely to take in examination is due. B, if any, preparing a bundle of documents binding them serially, with the exception of the bundle retained by the Director of Public Prosecutions for purposes of production in evidence, and tabulating the list of documents in the bundle, describing each document, paginating each serially, and indicating the corresponding number of pages for each document. And where only part of the document is relevant, highlighting the relevant part of the document. C, if the number of documents cannot fit one bundle, the prosecution is at liberty to serialize them in volumes. D, the prosecution is directed to serve the same list of witnesses and bound documents upon the accused or the accused's counsel, whichever is applicable, before the next mentioned date. E, the prosecution is further directed to share with the court the following: the tabulated list of witnesses and the tabulated list of documents only. Can be read by yourselves. 110, that all documents provided by the proposed surety as security in this regard shall be subject to verification by the investigation officer at the cost of the state. Roman 11, that the first accused is not permitted to exit Kenya except with the express permission of the court. And Roman 12, the first accused is one against offending a sub judice rule. In this connection, except in the court proceedings to ensue, the first accused is one against discussing in public, including in or with the media, the merits or otherwise of this case. B, that the first accused is hereby notified and accordingly undertakes which of any of the foregoing conditions shall attract consequences as prescribed by law, including but not limited to cancellation of the bond of interest, with the attendant consequence of being held in remand, prison, until conclusion of the case. Finally, in compliance with Article 52G of the Constitution, the prosecution is directed to supply all documents upon which the state will place reliance to the defense before the next mentioned date. In this regard, the prosecution shall be deemed to have complied by doing the following. A. If any, tabulating the full list of prosecution witnesses, briefly indicating the nature of evidence each witness will present, unless the witness is protected, and the approximate time each witness is likely to take in examination issues. B. If any, preparing a bundle of documents, binding them serially, with the exception of the bundle retained by the Director of Public Prosecutions for purposes of production in evidence, and tabulating the list of documents in the bundle, describing each document, paginating each serially, and indicating the corresponding number of pages for each document. And where only part of the document is relevant, highlighting the relevant part of the document. C. If the number of documents cannot fit one bundle, the prosecution is at liberty to serialize them in volumes. D. The prosecution is directed to serve the same list of witnesses and bound documents upon the accused or the accused's counsel, whichever is applicable, before the next mentioned date. E. The prosecution is further directed to share with the court the following: the tabulated list of witnesses and the tabulated list of documents only. F. All copies of the tabulated list of witnesses and the same band of documents held by all parties shall be identical to the originals held by the state. Very finally, this matter is allocated to court number 4 for further directions, hearing, and determination. This connection will be mentioned before court number 4 on 3rd of June 2025 at 9:00 a.m. for pretrial directions.
Graciously take your room, and we propose to appreciate your help. Secondly, we pray for summons for the second accused to report to EACC by tomorrow or the day after tomorrow. That is all your intelligence.
So I just take the opportunity to thank you for your patience and being able to produce a very detailed movie within a short period of time, which we are obliged about. We are grateful.
I also wish to thank you most profusely. I wish to thank you most profusely for the attention to details that you bring to the matter. I have never any doubt in your mind that you arrive at the right position. Two issues which I'll make reference to very briefly, conscious of the fact that I'm sure you're tired, you've spent more time than all of us and together. Insofar as the office being secure, the office of the distinguished governor, it is our plea that whatever visits that are to be made by the EACC or the investigative team, it is only fair that proper notice are furnished and the counsel for the accused person is also present to avoid a situation whereby is prejudice by whatever activities that may take place in that office. That is one. Secondly, Your Honor, I say this with a lot of respect. I do not wish to cause drama. I am at a stage in life and in the profession where I prefer to deal with issues as opposed to drama. There's a lot of police officers who are already outside the court, and there's an indication that there could be an attempt again to rearrest the accused person to defeat the very purpose for which this bill has been granted. Consequently, we will be to receive an undertaking from the prosecution, just as the undertakings have been made obligatory on the part of the accused person regarding how he is to conduct himself. We will also wish undertaking for it given in front of you that there is no intention at all to again cut away the accused person and take him to custody to defeat the purpose for which we applied for bail and which we granted orders after very elaborate submissions. And in the event we don't give that undertaking, it is our humble plea, Your Honor, because you can't grant orders that are in vain, that you exercise your discretion and extend that way to anticipate again, to also cover any intended arrest, if at all. We are giving an undertaking, in fact I'm giving a personal undertaking, as an officer of this court, and somebody who has practiced in these courts and also practiced in the various institutions, that if he is employed at any given time, he will surrender. Nobody needs to go to knock at his door, nobody needs to pounce on him as if he's a criminal for him to be brought to court. We bring him ourselves. Thank you very much for what you've done today. Is visible in the tenets of justice. In addition to what our guilty leader has said, I would like you to take into account that to give directions to us to the custody of the office of the governor. The custody of the office of the governor to be secure and to be fair on both sides of the coin. Should we like to consider that we have a concurrent custody of the office of the government, so that we will not give any doubts that will lead to the fruits of a poisonous tree, even we make that in reference to the Rwanda case of 1967. And that any evidence obtained unlawfully without justification will always be rendered unlawful as having been obtained through the fruits of exoneration. Thank you, John.
Well, in relation to the 3 months and the office of the government, we want to bear in mind that the governor's office is executed by the governor, and the CECs. Could you tell me now to do further directions to always, so that in the event the governor is needed to execute his constitutional mandate, probably there will be a way of doing it. That office is now let's just arrange your own. And it means the 2 months the owner is not able to work. And that goes against the constitution of the owner and against the people of this country. And thank you.
Finally, with respect to the same, permit me to address the court on the issue of where we find ourselves as a country in terms of budget cycle. We the budget cycle that affects the national government and the county government.
Sorry. We need to understand if Mr. Njeri is seeking a review of your decision so that we prepare to answer. Because we understood what was being done on the other side to be comments for the ruling. But the trajectory is taking appears to be intentional on you varying certain aspects of that. We need it to come out clear so that we prepare, if that's the intention.
We just restrict ourselves to the issue of the two issues.
From the side, please leading.
I'll go alone. Yes, I think just give it this time I'm sure I have estimated properly. We are agreeable to notice being issued for the ESC when they go to access for propriety so that the person may represent the funds. We are not agreeable, however, to what Professor Ojakoya is calling concurrent custody. I've never heard about that. The office has been characterized, at least on our end, as a scene of crime. Your orders capture the protection for both sides, that if the investigators are to access, the notice to be given so that counsel for the accused person is present to protect his rights. We are afraid, or rather I'm afraid, but I've shared with my colleagues, we cannot give an undertaking. The role of the prosecutor is simply to institute an undertaking of proceedings. While, like I said, I have always had reason to believe Senior Macharia Njeri is a man of his word. But I do not have any basis, or I'm not blessed with the same information he has, that there may be an arrest after this. Secondly, arrests are done by investigative agencies. The ODP does not involve arrests. So unfortunately, we can't give that undertaking, but we join in the hope that there's no arrest happens. However, Your Honor, very importantly, should an arrest ensue on the basis of the same facts where the court has given a warrant, then counsel are very aware that they can come back to you and give and seek appropriate orders. I'm not able to go into possible arrest for any other offense which I'm not aware of. Maybe the senior would have done better to add additional facts. But for his suspicion, we are unable to give an undertaking. We join in the hope that there will be no arrest. But if the arrest is to happen, they know how to seek subsequent orders from the court, or even from the High Court if necessary. We are obliged. Thank you.
Now that the thing is clear, on the first point that there is no objection that we agree, and the second one, which is extremely important, they are in your hands. We do not want to live by hope. Even though the issue of hope will not be wrong here. So we will enhance, protect the first accused person, protect the integrity of the order that is granted. I've given an opinion of saying that whenever it's required, we will surrender him. And you can join me in that undertaking, both the first accused person and myself. So with that understanding, protect him. So that he is not again grabbed outside here, he was thrown outside this court.
Sorry, I don't know any position to ask. But we understand, say I will also be asking for and still be on some form. I don't understand. If that is true, then you can respond if that is true. You just need that clarification from him. If you see it as much, it was an oversight that I didn't respond to that which my senior sister reminded me. Can I just say a word on that? That this court lacks jurisdiction to grant anticipatory bail. And even if this court had jurisdiction, you have no material before you. What you have is the truthfulness of Mr. Sharia, which is not founded on anything else. So, number one, the court lacks jurisdiction, but even if you have the jurisdiction, you have no material to grant bail. Thank you.
And the officers of the court will say that the treatment very short and clear, because the truthfulness, then at the same time you address that truthfulness by saying that it's not true. At the end of the day, you are a judicial officer with powers, you can exercise your discretion and ensure that again the orders are not abused. That's what we are saying.
I have considered issues. Upon the first request from Mr. Mutembei, it is granted. The second accused, of course, serve the summons latest by tomorrow, 10 a.m. The accused to attend court not later than 22nd of May 2025. Relating to the question of visiting the office at ESDC, the request is granted. For the rest of each time ESCC wishes to revisit the office of the first accused, they shall be accompanied by counsel on record for the first accused. Concerning the issue raised by the Honorable Manzo, any other issue that restricting our rights traditionally is construed strictly in the narrow sense. So, denying the first accused access to his office for a period of 60 days does not at all stop the first accused from acting. The denial to access the office means that the physical office, and that is why it's specified for the period of 60 days. That is what it means. So that office, if ESCC after 60 days they're like, we are done, then if there are issues, the court will be approached. If there are no issues, of course, that is the end of that restriction. I did not wish to give permanent restriction as yes. However, if other courts in the future think that there is need for permanent restriction, that I'm not in control. What other issue? I think I've learned about that issue enough. Potential arrest. For potential arrest, unfortunately, all counsel seated here understand my importance. Before I understand. So I think the air court is just across the road. We can approach it for if there is a problem, but I want to believe we are not acting that way. As I am just expressing myself. I don't think we want to act that way. The less I say about that, the better. Allow me to stop there. Much of that. Copies, I've seen a few times. Copies will be available in a matter of about 8 minutes. Copies of the ruling. Quorum is as before.
That's correct.
I want to apologize for, just like Mr. Witty, I underestimated my case. I tried using one finger. My professor was a poet. This is a summary of the ruling. Of course, we know the background of the matter. I will not set out the background. Government Council, Mr. Witty and Mr. Akula, the state proposed release of the first accused on bond of bail, citing grounds set out in the affidavit sworn on 18th May 2025 by the forensic investigator of ESCC, Mr. Robert Roma, which for purposes of this application was clustered into three grounds. First, it was submitted the first accused is likely to interfere with witnesses. Second, it was submitted that the public safety dictates that the first accused is denied bail or bond. Third, it was submitted also the severity of the offenses justify denial of bail or bond. Through his advocates, led by Mr. Mashari and Jehu, first accused sought to release on free bond and or reasonable bail and or bond. Again, but the evidence placed before the court is insufficient to make the cut for competitive reasons. Owing to the constraints of time, the submissions of my prosecution counsel, Mr. Ombati, Mr. Witty, and Mr. Akula, representing the state as captured in the court record, are incorporated into this ruling, as if they are set out herein verbatim seriatim. Similarly, dictated by the same reason, the submissions of learned counsel representing the first accused, namely Mr. Mashari and Jeru, Mr. Njiru, Mr. Echesa, Mr. Sibiu, Professor Wajakoya, Mr. Nubi, and Dr. Hamima, are also captured in the, as captured in the court record, are also incorporated into this ruling as if they are set out in the ruling verbatim seriatim. This rule was considered grounds can be both in support and in opposition of bond and or bail in respect to the first accused. Gathering from the affidavit in opposition to bail, this submissions can pass by all learned counsel. Three questions for dissemination have commended themselves as follows. First, whether the state has made a case to justify a decision of this court to deny the first accused bond and or bail. Second, whether the evidence which was gathered from the first accused residence situated in the Milimani area within Kitale was unlawfully obtained. And third, whether the constitutional rights of the first accused were violated. I will analyze each question in turn. Relating to the first question, I will summarize. I have discussed the history of bail and bond in Kenya, the Republic of Kenya, both colonial and post-colonial. That led me to the Constitution of Kenya 2010, in particular Article 49, 1H of the Constitution, which is at the center of this application. I also discussed the provisions of sections 123 and 123 capital A of the Criminal Procedure Code. In particular, in actualizing Article 49(1)H, the Statute Law Miscellaneous Amendments Act 2014, number 19 of 2014, dated 24th November 2014, introduced into the Criminal Procedure Code Section 123A, which stipulates as follows: exception to right to bail. Subsection 1, subject to Article 49, 1H of the Constitution, and notwithstanding Section 123, in making a decision on bail and bond, the court shall have regard to all the relevant circumstances, and in particular, A, the nature or seriousness of the offense; B, the character, antecedents, associations, and community ties of the accused; C, the defendant's record in respect of the fulfillment of obligations and previous grants of bail; and D, the strength of the evidence of his having committed the offense. Subsection 2 provides that a person who is arrested or charged with any offense shall be granted bail unless the court is satisfied that the person, A, has previously been granted bail and has failed to surrender to custody, and that if released on bail, into brackets, whether or not subject to conditions, it is likely that he will fail to surrender to custody. And B, the last condition, should be kept in custody for his own protection. In my mind, therefore, I entertain no doubt that any accused post the 2010 Constitution, notwithstanding the nature of the offense, is entitled to release on bond or bail, save where the DPP adduces facts and evidence constituting compelling reasons. The prominent divergency from the repealed Constitution is that the Constitution of Kenya 2010 now enjoins the court to strike a balance between the rights of the accused and those of the victims. I'm skipping some parts for your own reading. I have cited several divisions in line of that principle of a delicate balance between the competing rights. have also considered the relevant policy guidance of March 2015 and the construction assigned to how that policy has been construed by the superior courts, and in particular in Republic against Richard David Alden, reported in 2016 in the electronic version of the Kenya Law Reports. So I have also discussed diverse considerations in decisional law and diverse grounds in decisional law, most of which I will not read one after another. I will skip to the standard of proof. What then is the standard of proof? And how should compelling reasons be presented? In Java against the Republic, in 1973 staff reports, it said 39, to observe that in opposing applications for bond, that is the Court of Appeals saying, this on ground set out here in above, it is not enough for the prosecution to make their objections and insinuations. It was underlined that the same objections should demonstrate how release of the accused will be detrimental to justice by being supported by cogent reasons and facts. The decision to grant or refuse bail is only based on probabilities and not certainties. The standard of proof, therefore, is on a balance of probabilities, as opposed to the standard applicable in proving criminal charges. Having carefully considered each of the three grounds advanced in support of the objection to bail and bond in the context of the four discussed statutory considerations, grounds plus the decisional law considerations and grounds, on a balance of probability, in summary, although palpable fear was apparent, unfortunately the evidence presented failed to generate persuasion in my mind that it is more probable than not that the first accused is likely to interfere with witnesses. I find the grounds of public safety and severity of the offences and persuasive. In any event, gathering from the foregoing principles, the apprehension of the state of interference of witnesses and exhibits can be addressed using alternative means in view of the drastic step of denial of bond. Wherefore, this court reaches a conclusion and the state has failed to present compelling reasons to deny the fact. Question B, whether the evidence which was gathered from the first accused's residence located in Milimani area within Italy was unlawfully obtained. Concerning this question, intentionally so, this court refrains from determining it at this stage on account of the fact that the nature of the question commends itself for determination by the trial court. Question C, whether the constitutional rights of the first accused were violated. Concerning this question, this court too refrains from determining it now on account of the fact that it was raised informally from the bar in a manner stripping it of the manner of pleading such questions as enunciated in the locus classicus and Arita Karimu. a principle which has since received adoration and affirmation by the Supreme Court of Kenya in a litany of cases. Further, this is a question capable of determination in another forum, separate disposition. Consequently, in regard to Mutembei, this court directs and orders as follows. A. That pursuant to Article 49, Clause 1, Paragraph H of the Constitution, and Section 123, Capital A, Subsection 1 of the Criminal Procedure Code, the first accused is admitted to both cash bail and bond. B. That the first accused shall be released upon executing a bond of Kenya shillings 1 million with one surety of the same amount. Alternatively, the first accused shall be released upon depositing cash bail in the sum of Kenya shillings 500,000 and providing 2 suitable contact persons whose particulars shall be captured by the registry, including copies of identity cards, their contacts, and other details that may be required by the registry. C. Upon release and while at large, and to address the apprehension raised by the state, the following conditions and restrictions shall apply. Number 1. That the first accused undertakes not to interfere with witnesses and or evidence. Number 2. In order to allow EACC to secure evidence and witnesses, if any, or if there is further evidence to be secured, the first accused is prevented from going to his office at the county headquarters for a period of 60 days running from today. Number 3. And the first accused undertakes that he shall neither commit any offense nor interfere with the investigations nor threaten witnesses in relation to this matter. Number 4. That in the event they are protected witnesses, the first accused undertakes not to flout the law and restrictions which govern protected witnesses. Number 5. That the first accused undertakes to appear before court as and when required. 6. The first accused undertakes to arrive in the courtroom at least 15 minutes to the appointed time for mention of hearing unless exempted from attending court physically. 7. That in the exceptional occasions where proceedings are conducted virtually, upon directions of the court, which will issue from time to time, the first accused undertakes to join the virtual platform at least 15 minutes before the appointed time. 8. That in case of bond, the proposed surety shall provide security acceptable to the court upon verification thereof. 9. Number 9 is joined with 8. It provides the kind of surety that is expected by the court. It's a long provision and read by yourselves. Number 10, that all documents provided by the proposed surety, the security in this regard, shall be subject to verification by the investigation officer at the cost of the state. Number 11, that the first accused is not permitted to exit Kenya except with the express permission of the court. And number 12, the first accused is warned against offending the subject is cruel. In this connection, except in the court proceedings to ensue, the first accused is warned against discussing in public, including in or with the media, the merits or otherwise of this case. B. That the first accused is hereby notified and accordingly undertakes which of any of the following conditions shall attract consequences as prescribed by law, including but not limited to cancellation of the bond of interest, with the attendant consequence of being held in remand, prison, until conclusion of the case. Finally, in compliance with Article 52G of the Constitution, the prosecution is directed to supply all documents upon which the state will place reliance to the defense before the next mentioned dates. In this regard, the prosecution shall be deemed to have complied by doing the following. A. If any, tabulating the full list of prosecution witnesses, briefly indicating the nature of evidence each witness will present, unless the witness is protected and the approximate time each witness is likely to take in examination is due. B. If any, preparing a bundle of documents, binding them serially, with the exception of the bundle retained by the Director of Public Prosecutions for purposes of production in evidence, and tabulating the list of documents in the bundle, describing each document, paginating each serially, and indicating the corresponding number of pages for each document. And where only part of the document is relevant, highlighting the relevant part of the document. C. If the number of documents cannot fill one bundle, the prosecution is at liberty to serialize them in volumes. D. The prosecution is directed to serve the same list of witnesses and bound documents upon the accused or the accused's counsel, whichever is applicable, before the next mentioned date. E. The prosecution is further directed to share with the court the following: the tabulated list of witnesses and the tabulated list of documents only. F. All copies of the tabulated list of witnesses and the state band of documents held by all parties shall be identical to the originals held by the state. Very finally, this matter is allocated to court number 4 for further directions, hearing, and examination. In this connection, there will be a mention before court number 4 on 3rd of June 2025 at 9:00 a.m. for pretrial directives.
Graciously take your room, and we propose to appreciate your help. Secondly, we pray for summons for the second accused to report to the PSCC by tomorrow or the day after tomorrow. That is only so I just take the opportunity to thank you for your patience and being able to produce a very detailed movie within a short period of time, which we are blind about. We are grateful. He also wished to thank you most profusely. Sorry? I wish to thank you most profusely for the attention to detail that you given to the matter. I have never any doubt in my mind that you arrive at the right position.
reference to very briefly, conscious of the fact that I'm sure your time you've spent more time than all of us in together. Insofar as the office being secure, the office of the distinguished governor, it is our plea that whatever visits that are to be made by the EACC or the investigative team, it is only fair that proper notice are furnished and the counsel for the accused person is also present to avoid a situation whereby is prejudiced by whatever activities that may take place in that office. That is one. Secondly, Your Honor, I say this with a lot of respect. I do not wish to cause drama. I'm at a stage in life and in the profession where I prefer to deal with issues as opposed to drama. There's a lot of police officers who are already outside the court, and there's an indication that there could be an attempt again to rearrest the accused person to defeat the very purpose for which this rule has been granted. Consequently, we wish to receive an undertaking from the prosecution, just as the undertakings have been made obligatory on the part of the accused person regarding how he is to conduct himself. We also wish an undertaking given in front of you that there is no intention at all to again cut away the accused person and be taken to custody to defeat the purpose for which we applied for bail and which you granted orders after very elaborate submissions. And in the event we don't give that undertaking, it is our humble plea, Your Honor, because you can't grant orders that are in vain, that you exercise your discretion and extend that way to anticipate review, to also cover any intended arrest, if at all. We are giving an undertaking, in fact I'm giving a personal undertaking, as an officer of this court, and somebody who has practiced in these courts and also practiced in the various institutions, that if he is required at any given time, we will surrender. Nobody needs to go to knock at his door, nobody needs to pounce on him as if he's a criminal for him to be brought to court. We'll bring him ourselves.
Thank you very much for what you've done today. Is visible in the tenets of justice. In addition to what our deputy leader has said, I would like you to take into account that the legal directions to us to the custody of the office of the governor. The custody of the office of the governor to be secure and to be fair on both sides of the coin. Should we like it considered that we have a concurrent custody of the office of the government, so that we will not give any doubts that will lead to the fruits of a poisonous tree, if I may make that in reference to the Milimani case of 1967, in that any evidence obtained unlawfully without justification will always be rendered unlawful as having been obtained through the fruits of exoneration. Thank you.
Well, in relation to the 2 months and the office of the government, we want to bear in mind that the governor's office is executed by the governor and the CECs. Could you point it out to me further directions around this so that in the event the governor is needed to execute his constitutional mandate, then probably there will be a way of doing it other than that office is his office. Now let's just again your own. It means the 2 months the governor is not able to work. And that goes against the constitutional norm and against the people of this country. And thank you.
With respect to the same, we need to address the court on the issue of where we find ourselves as a country in terms of budget cycle. We are the budget cycle that affects the national government and the county government.
Sorry. We need to understand if Mr. Njeri is seeking a review of your decision so that we prepare to answer. Because we understood what was being done on the other side to be comments for the ruling. But the trajectory is taking appears to be intentional on you varying certain aspects of that. We need it to come out clear so that we prepare, if that's the intention.
We just restrict ourselves to the issue of race, the two issues.
From the side, please leading.
I'll go alone. Yes, I think just give it this time I'm sure I have estimated properly. We are agreeable to notice the issue for the ESC when they go to access for propriety so that the person may be represented the funds. We are not agreeable, however, to what Professor Jakoya is calling concurrent custody. I've never heard about that. The office has been characterized, at least from our end, as a scene of crime. Your orders capture the protection for both sides, that if the investigators are to access, the notice to be given so that counsel for the accused person is present to protect his rights. We are afraid, or rather than afraid, but I've shared with my colleagues, we cannot give an undertaking. The role of the prosecutor is simply to institute an undertaking of proceedings. While, like I said, I have always had reason to believe Senior Macharia Njeri is a man of his word. But I do not have any basis, or I'm not blessed with the same information he has, that there may be an arrest after this. Secondly, arrests are done by investigative agencies. The ODP does not involve arrests. So unfortunately, we can't give that undertaking, but we join in the hope that there's no arrest happens. However, Your Honor, very importantly, should an arrest ensue on the basis of the same facts where the court has given a warning, then counsel are very aware that they can come back to you and give and seek appropriate orders. I'm not able to go into possible arrest for any other offense which I'm not aware of. Maybe the senior would have done better to add additional facts. But for his suspicion, we are able to give an undertaking. We join in the hope that there will be no arrest. But if the arrest is to happen, they know how to seek subsequent orders from the court, or even from the High Court if necessary. We are obliged. Thank you.
Now that the third is clear, on the first point, that there is no objection that we agree. And the second one, which is extremely important, the reliance. We do not want to live by hope. If there was the issue of hope, we would not even be where we are. So we will enhance, protect the first accused person, protect the integrity of the order that is granted, I've given an appointment of saying that whenever he is required, we will surrender him. And you can join me in that undertaking, both the first accused person and myself. So, with that understanding, protect him. So that he is not again grabbed outside here, he is thrown outside this court.
Sorry, Your Honor, I don't know any position to ask. Or do you understand, Senior will also be asking for anticipatory bail of some form? I don't understand. If that is true, then you can respond if that is true. That's that clarification from him. If you see me, it is as much. It was an oversight that I didn't respond to that which my senior officer reminded me. Can I just say a word on that? On anticipatory bail? That this court lacks jurisdiction to grant anticipatory bail. And even if this court had jurisdiction, you have no material before you. What you have is the truthfulness of Mr. Sharia, which is not founded on anything else. So, number one, the court lacks jurisdiction, but even if you have the jurisdiction, you have no material to grant bail. Thank you.
Just to clarify, I cannot grant over what I think. And we have officers in the court, and we say that the treatment, very short and clear, that the truthfulness, then at the same time we address that truthfulness by saying that it's not material. At the end of the day, you are a judicial officer with powers, you can exercise your discretion and ensure that again the others are not abused. That's what we are saying.
I have considered issues. Upon the first request from Mr. Machi, it is granted. The second accused, of course, serve the summons latest by tomorrow, 10 a.m. The accused to attend court not later than the 2nd of May. Fine. relating to the question of visiting the office at ESCC, the request is granted. For the rest of each time ESCC wishes to visit the office of the first accused, they shall be accompanied by counsel on record for the first accused. Concerning the issue raised by the Honorable Manzo, any other issue that restricting our rights traditionally is construed strictly in the narrow sense. So, denying the first accused access to his office for a period of 60 days does not at all stop the first accused from working. The denial to access the office means that the physical office, and that is why it's specified for the period of 60 days. That is what it means. So that office, if ESCC after 60 days they're like, we are done, then if there are issues, the court will be approached. If there are no issues, of course, that is the end of that restriction. I did not wish to give permanent restriction as yet. However, if other courts in the future think that there is need for permanent restriction, that I'm not in control. What other issue? I think I've clarified that issue enough. Potential arrest. For potential arrest, unfortunately, all counsel seated here understand my limitations. Before I understand. So I think the air court is just across the road. We can approach it for if there is a problem, but I want to believe we are not acting that way. I'm just expressing a feeling. I don't think we want to act that way. The less I say about that, the better. Allow me to stop there. Much of that. Copies, I've seen a few times. Copies will be available in a matter of about 8 minutes. Copies of